Lordship, I beg to mention item number 15. This matter has been wrongly listed in the hearing column, Your Lordship. This matter actually has been referred to mediation.
So mediation report hasn't been received.
Actually, what happened here is the mediator, Your Lordship, couldn't appear, so we couldn't even furnish the copy.
May I please, Your Lordship, I'm appearing on behalf of Ms. K. Wangmo, the mediator. She has requested me to inform the Honorable Court that she won't be able to appear in this case because she is having some personal difficulty.
The mediator was appointed by this court.
Yes, Your Lordship.
I mean, by naming her.
By naming her. That is by order dated 5/8/2025, Your Lordship.
Also,
I'll refer the file then.
he came to know about the appointment only day.
Otherwise, also the matter is wrongly listed, no?
Yes, Your Lordship.
So let it be listed in the orders column.
Your Lordship, in that case, because both the parties are ready for the mediation. So in this case, if a new mediator is appointed, and then the matter can be referred to the mediation, Your Lordship. Then a date can be fixed.
Yeah, Ms.
R. Taku, Your Lordship.
R.
Taku,
MS R. Taku appears on behalf of
the appellant, Your Lordship.
appellant. MS.
P. Sangeeta.
So appellant counsel appears for the respondent.
K. Wangmo, Your Lordship. The mediator.
For the mediator. So appears on behalf of MSK Wagmo, learned counsel, who was appointed as mediator in this case by the order dated 5/8/2025 of this court. It has been submitted before this court by MS so-and-so, appearing on behalf of Wagmo, K. Wagmo, that though she has been appointed by this honorable court to be a mediator in this case, due to what reason?
She is having some personal difficulty.
Due to some personal difficulties, she won't be able to act as a mediator in this instant matter. In view of the aforesaid submission made, this court, who are the other mediators?
I'm a beer of catering.
Is there a list of mediators? Difficult list. You agree we were on name of the mediator, both of you?
Yes.
You give a name. Can you suggest a name?
Should I have to go through the name?
Because there is a list. If both the parties agree, then I can appoint somebody from me. Give the list to.
Otherwise, Lordship can appoint.
Because I don't know any. I'm pretty new here. I don't know anybody. So if you can suggest somebody's name, then it will be better. Both of you can agree on a particular name.
Lordship, SV Sum V Darang, Your Lordship.
Okay, give it to me. Which?
Serial number 7.
To write in view of the above submission made, this court appoints Mr. S. V. Darang.
Srimati, Your Lordship.
Srimati S. V. Darang, learned counsel, to be the mediator in the instant matter. The parties to furnish the copies of the petition along with annexes to the learned mediator. The learned mediator will submit a report after 3 weeks. Yes, after 3 weeks before this court. List this matter after 3 weeks. Yeah. You are?
I'm a beer of catering and Kumo.
You are appearing for?
Respondent.
Respondents. Mr. So-and-so appears for the respondent.
Should I mention item number?
What's item number?
12.
12, yes.
Lordship, the service upon respondent number 6 is still awaiting. And last occasion, the record was called for. Then the record is yet to come. Therefore, in respect of respondent number 1 to 5.
1 to 5, your lordship, we are appearing today for the first time.
It is Mr. So-and-so appearing on behalf of the petitioner. Mentions in the bar that service report in regard to who?
Respondent number 6 is still.
Respondent number 6 is still awaited. Please this matter after 3 weeks.
There is interim.
The interim order so passed earlier by this court is extended till the next date of listing.
Lordship, if respondent number 1 to 5 appearance, that can be recorded, your lordship.
And so learned counsel appears on behalf of respondent number 1 to 5.
1 to 5, your lordship. Deeply obliged.
Yes.
Yeah. Item number 16. Lord. The
Item
hearing-
number 16, yes.
This matter may be adjourned since that is not ready, like EP that are not there. After 2 weeks.
On the prayer of Mr.
Itapa.
Tapang, Tapak appearing on behalf of the petitioner. Let the matter be listed after 2 weeks.
Item number 1.
Yes.
Please, your lordship. Lordship, this anticipated bail application, it's in connection with actually PS case. And the alleged offense is 468.
You don't have the FIR.
Lordship, we have tried to obtain the FIR,
But
Lordship.
I mean, this information that you have given, those are correct?
Correct, Lordship.
I mean,
That
the
is correct,
section and all,
Lordship, that is correct, Lordship.
that you have procured, but you could not procure the FIR.
Lordship, we have, in fact, I have annexed the form that is submitted before the CGM,
Which form,
Zero.
which form?
Lordship,
Page?
page 27, annexure 6, Lordship.
Or that you have applied for the.
Lordship, yes. Now, as per the information furnished by CGM court, Lordship, they say that the FIR has not yet been supplied to the CGM court. Now, as per Lordship is aware, Lordship, within 48 hours, they are supposed to transmit the copy of the FIR. Now, this is the way.
What is the offense?
Lordship, 468. Now they are alleging, Lordship, initially also they have filed one complaint, Lordship, page 26, Lordship. That was settled, Lordship. I was summoned. I appeared before the police station. I have clarified everything, Lordship.
Some mediation happened and the
Exactly.
FIR was filed against the mediators,
Exactly.
correct?
Yes, Lord. Now that alleged documents that is alleged to have been forged is at page 21, Lordship. This is the documents that they are alleging that.
When can you, Mr. PP, when can you submit that CD case diary?
It's from actually on the next week, Lordship.
Because it's an anticipatory bail, so you should not take much time. The only thing is that the police court wants to look into their FIR and like whatever. So case diary will be having their FIR and all. Correct?
Yeah. Wait till next week, Lordship.
No, till then, Lordship, I may be protected, Lordship.
No. Let the CD come.
Lordship, this is a matrimonial dispute basically, Lordship, rising up.
I understand, but there are some allegations. There are some,
Allegations, Lordship will kindly.
this dispute was going on for quite some time. I mean,
Lordship, correct. Lord. Page 26, Lordship.
so let it come next week. And the next week we'll hear it. I'm here till next week.
All right. Lordship, since he is a government employee, Lordship, so
So like, see, I mean, this was filed on when? This FIR was supposedly filed on when?
Lordship, date we are the moment we came to know that FIR has been registered, Lordship, we have applied for the certified copy, Lordship. The date is, Lordship, 5th of this month.
We were not aware.
Lordship, when the FIR was registered, that part we are not aware of. But we came to know, Lordship, that FIR has been registered.
Anyways, till now we have been awaiting, so let us wait for a couple of days. Wait for a couple of days, next week by Monday.
Can it be on Monday, Lordship?
Monday or Tuesday, we'll take up.
Tuesday, Lordship. On Tuesday, Lordship.
Do it on Tuesday. Tuesday we'll take up.
All right, Lordship.
Heard Mr. So-and-so, learned counsel appearing for the petitioner. Also heard Mr. D. Loy, learned PP for the state respondent. This is an application under section 482 of BNS filed by Sri Gatam Tako Tara in anticipation of arrest for offence allegedly under section 468 of Indian Penal Code 1960 in connection with Gachuli Police Station case number 11/2025. Apprehending his arrest. That you have already written. The matter relates to some ongoing marital dispute between the petitioner and his wife. Though the dispute was attempted to be settled in the Kebang stroke Mal and some mutual divorce agreement was executed. The dispute could not be settled. And ultimately it resulted in filing of an FIR by the wife of the petitioner. It is submitted by the learned counsel for the petitioner that though he has applied before the CGM
Zero, Lordship.
Lower Sanctuary District for the certified copy of the FIR. The same has not been furnished to him as yet. As he is seriously apprehending his arrest, he filed this application. Heard Mr. D. Loy Leonard FPP, and he submits that, FPP, and he submits that.
PP, Lordship. PP, Lordship.
PP, Leonard PP?
Yes.
Is it? Yes. So he submits that the case diary can be submitted the next date of listing of this matter, that is on Tuesday. Accordingly, list the matter on 26 for consideration of the pre-arrest bail application. List the matter on 26th.
Lordship, till then, no coercive action may be taken, Lordship. Otherwise, I'm a government servant, Lordship. If I'm arrested, Lordship, this become infractious.
Till the next date of listing, the authorities, the government authorities, the prosecution authorities will not take any coercive action. against the petition.
Obliged.
Item number 2.
May I submit, my lord?
Yes, yes.
My lord, I will start with my lord, annexation number 9, my lord. Page number 173, my lord.
So before this, learned APP, what is your, this thing? I have gone through this. What is your contention in this?
Your Lordship, as per my understanding, Your Lordship, even prior to the conclusion of the trial, Your Lordship, a document is sought for, and if since the document was also reflected in the charge sheet that was filed earlier, Your Lordship, the court can at any point before the entire trial is completed can seek for the said documents. Your Lordship.
But like then again, that document has to be introduced before the trial court
Yes.
by way of some witness. How will
No.
you do it?
No. Since, Your Lordship, there was
165, I understand, 165.
if there was no reflection of the said documents by the IO when the charge sheet was filed, that would have been a different case, because that would have been a evidence that was during the trial that has come to the knowledge of the magistrate, Your Lordship. However, this document was already reflected in the charge sheet, Your Lordship.
But what
Also, the
stopped you,
statement,
but what stopped you till now and the learned PP there to point out these things before the court, now all evidence is closed, Q1P was recorded,
yes, Your Lordship.
then the matter was fixed for final hearing,
Yes,
and that stays. I mean, some clarifications under 165 is of course, that is allowed.
yes, Your Lordship.
Now, new documents which was not there before the court,
Yes, Your Lordship.
which may have some substantial effect in the whole file, is being introduced, though it was there in the charge sheet. I understand it was there in the charge sheet. But like what stopped the PP? Now the whole thing will, I mean, that they'll have to be given chance.
Yes, Your Lordship.
Controversy.
As per the very recent judgment of Your Lordship says Samir Sandhir, Your Lordship, the apex court has stated that the only criteria that would allow such introduction of the documents, which was not produced while filing of the charges, is that if those documents were mistakenly not produced before the magistrate. The word mistakenly, Your Lordship, that ought to be disputed at the stage, Your Lordship. And subsequently, if the document is being taken as an evidence, Your Lordship, the witnesses are to be called for only for the limited purpose of the contents of that document, Your Lordship.
Q1P is already
Otherwise-
recorded.
Yes, Your Lordship, there is no bar otherwise. It does not prohibit that such cannot be. The only contention that can be brought before the magistrate is that if that document was mistakenly not produced before the learned trial court, or there was no mistake there was a deliberation on the part of the, prosecution.
What was the order passed by? Let us see the order
yes, Your Lordship.
passed by the learned trial court.
Page number 177, my lord. 177.
Yes, 177. Correct. Please read out.
Out of six accused persons, three such and such are produced before the judicial custody SEPA. Three more accused persons named such and such are also present. Learned counsel such and such representing all the accused appearing and so the learned PP Mr. such and such. Matter was fixed for final argument to be held today. However, before final argument begin, learned PP has submitted that in the summary of the charge sheet, second last paragraph of NCN or 4, IO has prayed the court while filing the charge sheet that on the receipt of this copy of the CAP and CDR, the mobile number seized in the case, same shall be filed before the concerned jurisdictional magistrate court.
What is CDR? What is CDR? Call record. Call record.
All data record.
Call record.
Same shall be filed before the concerned judicial magistrate. However,
Jurisdictional magistrate. However, till that a process CAP and CDR have not been submitted to this court, who is a vital and
so the plea is not mistake or something.
Yes, Your Lordship.
Then let's go on.
it is also submitted that the two co-accused persons such and such had money transaction with another co-accused person named such and such through bank account online during the investigation period. But the record of such transaction through Google online or banking is also not submitted in the court, despite Same has been already mentioned in the summary of the charge sheet, which must be available with the concerned banking online authority. It is prayer of the learned such and such to direct the IO to obtain above material and relevant record of the prosecution so as to submit it to the court for the appreciation of the evidence. Learned Defense Counsel on the contrary has objected the prayer of the PP on the ground among the other that the IO and the learned PPS an opportunity of submitting or exhibiting the apposite record, if any, during the evidence stage. Now, a case is at the stage of final argument, during which it may not be permissible to allow for such additional prosecution record as it could prejudice the accused person. Upon hearing the learned counsel of the parties, I perused the report, particularly summary of the charge sheet, and found the submission of the learned PP to be correct. At this juncture, it may be advisable to revisit the provision of the Section 165 of India Evidence Act 1872, which is report is hearing. Judge's power to put question or order production. The judge may, in order to discover or in obtain proof, proper proof of the relevant fact, ask any question he please in any form at any time of any witness or of the party about any fact relevant or irrelevant, and may order the production of any document or thing. And neither the party nor the agent shall be entitled to make any objection to any such question or order, nor without the leave of the court.
So
To
what is your submission on that? 165 allows.
My lord, my humble submission, my lord, if I understand the 165, my lord, that can, yes, it certain extent it allow a calling of the record, my lord. But under 165, my lord,
165, it has been clearly written about any fact relevant or irrelevant.
my lord, to the
May order the production of any document,
documents, my lord.
any document or thing. And in
Right.
this case, this is not something which has been sought for outside the record.
My lord.
It was already there in the record, because it has been already mentioned in the, let us go to the charge sheet. Charge sheet is there.
Yes, in charge sheet it is mentioned, my lord. I have to consider. My submission,
Charge sheet, it is there.
Yeah.
So it, only thing that learned court sought for,
Yeah.
that a document which has been already mentioned in the charge sheet.
charge sheet.
The problem only happened here is that it was sought in the very late stage of the trial,
Try.
because the final argument was supposed to happen.
Supply.
Now, in that case, if the learned court thinks that the document is of very vital nature, and somehow it was not brought on record, and for proper adjudication of the case, and for coming to a right conclusion in the trial, the court actually wants to have a look on that document. So in that case, why it should not be allowed?
Yeah, my lord, my lord, now next page, my lord, will see, my lord, or page
Next-
number,
Next
Page
page,
number.
page number?
annexure number, my lord, 13, my lord,
Yes,
181, my lord.
this is WT message.
WT message, my lord, directing the witness and the accused to appear before the IO, my lord. Now, my lord, if this is allowed, my lord, I humbly believe, my lord, this amount to be further investigation.
You know, who has sent this message?
This is IO, my lord, in terms of the disorder, my lord, of the learned court, my lord. Record, yes, my
So,
lord.
do you want to submit that document is still not there with them?
If suppose documents with the police, my lord, yeah, they can produce, my lord. I have no objection with that, my lord.
But
Now, in terms of,
but from this, you wanted to show that the document is still not there with them.
and no, I'm not saying so, my lord. I am saying, my lord, by 165 years, learned trial court had order to produce, my lord. Now, but that cannot be take as a part authority to further investigation the matter at this stage, my lord. Further investigating the matter and calling the harassing the witness. Next page also, my lord. How, my lord, if this is that will be further investigation, my lord. Now, if further investigation, whole thing need to be revisited, my lord, starting from the projection evidence, my lord. So I humbly believe, my lord, this authority is not under 165, my lord.
authority, yes, my lord, record with the police, my lord. If they has not produced, they can produce, my lord. But under the guise of this 165, my lord, further investigation, my lord, I humbly believe that is not authorized, my lord. So it is only because of this order, my lord, impine order, my lord. Now police has, again, my lord, further investigating the matter, my lord. If that, my lord, the block has again to be returned, my lord.
What is this order on Annexa 14?
14, my lord, 14, this is also, my lord, to some other person, my lord, ordering, my lord, someone, my lord, to witness, my lord, Sri Devtana, Sri Puja Dada. This is all a witness. And kindly request to inform the someone to appear before the IO at the PSA, my lord.
No, read this order. Out of 6 persons, so and so, more occasions are absent.
Page, no, my lord,
Page 183.
183,
3.
180.
Learned so and so appear.
This is subsequent order, my lord.
What is that order?
Order, my lord,
Present.
out of 6%,
Report.
such and such, such and such. 3 more accused person named such and such.
Taken to collection of
The
the
absent.
record. The prayer is
Yeah, SEPA is present, but without record. So with such and such. It is the prayer of the IO that some time may be given to him for the collection of the required requirement. Now collecting, I have humbly believe, my lord, they are praying for further investigation. Now, further investigation, my lord, under the 170 or
So at this case, see, I will issue notice in this. Yes.
Otherwise also, this is not a further investigation. There was a clear direction that you submit the IO to collect your lordship.
No, you are again issuing summons, calling them.
No,
No,
Your lord-
see, let us be very clear.
yes, your lordship.
Under 165, you can do only some clarification you can sort for.
Yes,
Or if some documents are there, which may be, if the court thinks that those are vital documents, those can be produced.
yes, sir.
But now again, you are summoning these people.
Yes, this part with regard to the WT messages, your lordship. If that is challenged, that's a different thing, because I concede with the fact that calling up the witness
Yes,
again by that would,
now
that-
why this IO is calling these people?
yes, that would be that I concede with my learned friend, your lordship. But with regard to the impugn order, there is no wrong in the impugn order.
No,
otherwise.
impugn order is fine, but like, I mean, taking the regard of that order, this IO is calling these people.
Yes,
What is this? It can be that
I completely agree to this.
taking support
WT
of that order,
messages.
like they are
Yes.
doing this. So we'll issue notice in this.
At this, my lord, I humbly, at the next date, my lord, seen at page 83, my lord.
Page?
183, my lord, is 26/8/2023, my lord. At least this action by the police, my lord, I believe, my lord, this, as this order is in consequence to the order, my lord, this order needs to be stayed, my lord, for the inner justice.
No, let us see let us call for the records. Let us call for the records. And when is the next date fixed?
26.
26/8/2025, my lord.
20?
26, my lord, 26, this month, my lord, 26.
'26 means next Tuesday.
Next
Yes,
Tuesday.
If some sort of protection is not given, my lord, I believe, my lord, this is becoming practice, my lord. I will be, this whole accusation witness will be harassed by this action of the police, my lord.
So what is your prayer?
My prayer, my lord, this order at the returnable then need to be stayed, my lord, so that this police will not take. Otherwise, my lord, in page 83, my lord, particularly, it is prayer of the IO that the same time, some time may be granted him for the collection of the required record, my lord. It is a strict prayer of the IO, my lord. The above prayer is allowed in the interest of prayer now. Concern, this is consequential order of this impugn order, my lord.
Where is this court located?
It is at SEPA, my lord, who is coming, my lord.
How much time will it require?
If your lordship, since the PCR is to be received by the registry in the main.
Usually how much time it takes?
It will take at least 3 to 4 days, maybe,
3 to 4 days.
if some urgency is shown in.
Even if, my lord, this order is not stayed, my lord, at least this action of the police, my lord,
Hmm?
the action of the police, my constitutional action need to be, my lord, restrained, my lord. Otherwise, whole this issue become my.
If I may
Petition
just
begin.
suggest, Your Lordship, if that is the interim order, because I also concede with regard to the action of the police, Your Lordship. If Your Lordship, if I may suggest that Your Lordship may pass an interim order in terms of that if such documents are received by the concerned magistrate, Your Lordship, that no proceeding on receipt of that document, only with regard to that, Your Lordship.
No,
Or
that will,
just like a sealed cover, Your Lordship, because the issue will start once these documents are
no, submitting, see, submission of those documents, I don't think this court has any problem. Right. But problem is that while submitting these documents, they're investigating again.
yes,
That has to be stopped.
that itself
So,
is
that has to be stopped. That is what he's saying also. So what is your suggestion on that?
my suggestion is that if, because the next date is on 26/8, Your Lordship, on receipt of such documents, because that production and that,
But in the meantime,
process-
in the meantime, if they call these people again,
Your Lordship, even because the issue here itself is that the subsequent action of the IO in procuring that document itself is in challenge otherwise in this petition, Your Lordship. So if, even if that document is being
no,
produced,
it is not under challenge, but it is totally against law.
yes,
It's not required to be challenged in court.
my suggestions would be, Your Lordship, that since the entire order and the subsequent action by the IO itself is before this court, Your Lordship, even if the IO proceed and procure that document, that would itself be decided by this court in this petition, Your Lordship. So even if the documents are being produced by the trial court, Your Lordship, the trial court may be directed not to act on that.
No, that I understood, but only problem is that in between, if these people are harassed again by the police, calling them, summoning them,
Yes,
then the investigation, then further investigation goes on.
yes.
That cannot be allowed. No? Don't you agree with that?
So in terms of that, Your Lordship, that because the impugn order, there is no wrong on in terms of impugn order.
That will
So
examine. That this court is going to examine.
Yes, Your Lord.
But in the meantime, if the police keeps on calling them, summoning them for further investigation, if police calls them, it will amount to kind of doing some further investigation. Whether when the trial is already on, it is in the verge of completion. Final argument is whether the new investigation you can do, the police can do.
In that case, these WT messages may be stayed otherwise, Your Lord. Because only through the action of the police by these WT messages that the action has been proceeded, Your Lord.
Okay, I'll do one thing. We'll issue notice on this matter. PCR will be called for. Then as far as the action taken by the police by summoning these people will be stayed.
Yes, I agree to that.
Will do?
My.
So you take their names. So one is like I will issue notice. Second, call for CBS, call for trial court records. And stay of further police action.
My.
That will do. So I'll pass the order.
Yes,
High level.
I'll just go through a little bit details, then pass.
yes.
High level.
Today only I'll pass the order.
Item number 3 to 5.
My Lordship, item number 3 is represented by Mernal Kolita, Guwahati-based lawyer,
Yeah.
and he was seeking adjournment of that case. And item number, although my name is reflected, and item number 4 and 5 that can be heard.
My lord, all the cases may be heard together, my lord.
Because
These all are connected matter, my lord. Item number 3, they are avoiding because, your lordship, in that case, there was NBW was issued and we raised an objection on maintainability, my lord. And this case was filed long time back in 2022. As on that, they have not pursued the matter. Now they are avoiding it and just skipping to the other item 2 items, my lord.
Yeah, I have seen this order 6. Why you are not appearing?
although item number 3, although my name is reflected, but I am not appearing on that case since the
No,
matter.
you are not appearing, but you were sitting time on behalf of Mr. Kalita, no?
Yes,
Who is-
Kalita.
who is appearing? Why he is not there in the court?
Although
And like
there-
he's,
There's some difficulty.
see
On the
this
next
order, when was the NBW issued?
No, this one.
No, it's,
Yes, lordship.
it was
And,
sometime
your lordship, 2022, my lord.
Hmm?
2022, my lord.
2022. And you have challenged the NBW and you are missing from the court.
I think no interim order is here. No interim order.
Interim is not there.
Yes, your lordship. Interim is your lordship not there, but your lordship, the issue here is NBW was issued long time back in 2022. He might have been proclaimed, my lord, also.
But why are you not arresting him?
Your lordship, they are not whether your lordship, we don't know the status of this case as on date, your lordship, because there is no record was called for, your lord.
Okay, today I'll give them time.
On item
These
3.
3 matters has to be heard
I think
together.
3 and 4, I can, that may be here today.
No, this is together. I mean, this has been listed together. No?
Yes, absolutely, man.
Saying that they have some connection. Mr. So-and-so appearing on behalf of Mr. M. Kalita, learned counsel for the petitioner, submits that Mr. M. Kalita, who is stationed in Guwahati, could not be present today in the court to pursue the matter. In view of that, he is seeking for adjournment of the matter for 2 weeks.
Can particular date may be given because he is the out station lawyer. You can maybe.
After 2 weeks, that will be.
After
After 2.
Yes.
Which date may be given because,
No, after
9th of,
Huh?
9th of September.
9th of September.
9th September.
After
Then after there is a calendar.
let them decide the date and give it to the court. That will be more convenient.
Learned APP, Mr. T.A.K. appears on behalf of, in which matter? You are appearing
Yeah, on all the matters, my lord. Private respondent is there, madam.
So there will be same order on there.
Yes, your lordship. Absolutely.
And we MS
J.
appears on behalf of informant. Anybody else is appearing? No.
No.
So, Mr.
Tita.
Apas appearing for the in item number 3. And criminal petition 37 Q2.
In that case, sir.
You are appearing for the.
Yes.
I also you are appearing for the.
Yes.
And Mr. T.A.K. Learned APP appears in all these matters.
Yes, madam.
And you are informant in which matter?
All matter.
All the. So same order will go.
That is.
Obliged, your lordship.
Item number 6.
My lord, that,
That statement has come.
yes, your lordship, it has been received, ma'am.
Yes, you have seen this.
My lord, yes, please.
My lord, the submission, my lord, I have advanced, my lord, in the last occasion, my lord. In addition to that, my lord, I just like to place one judgment regarding, my lord, delay of.
You please refresh me. Refresh me a bit.
Yes, my lord. My lord, this case is regarding, my lord, false FIR, my lord, filed by the alleged complainant, my lord. In fact, my lord, the complainant, my lord, he had never filed FIR, my lord.
Complaining hasn't filed FIR.
Yes, my lord.
Who has filed FIR?
My lord, unknown person came to the shop of the complainant, my
No, no,
lord,
no,
and
yes.
they had obtained the signature of the complainant forcefully, my lord. And later, my lord, was come to notice that, my lord, an FIR against the petitioner was lodged by this 3%, my lord. That, my lord, is, my lord, substantiated by the statement of the complainant, my lord, before the trial court, my lord. That last occasion I have shown, my lord. My lord, may kindly come to page number 100, my lord. Yes, my lord. My lord, this is the statement before the trial court, my lord, by Anil Chandra Kaur, my lord, the alleged complainant, my lord.
Complainant is now deceased.
Yes, my lord. Now disease, my lord. What happened, my lord, in the year 2006, my lord, there was this election of the Eternal Market Welfare Society, my lord. And the petitioner, he was one of the contestants for the post of General Secretary. There were other two candidates, my lord. So therefore, there was political rivalries between the party. And in order,
That I remember.
yes,
So now deposition, what does he say?
it says, my lord, may I read, my lord? I cannot recall lodging any complaint against Lokamta law. The document shown to me marked as Fee Exhibit 1 is not a complaint lodged by me, and Fee Exhibit 1 is my signature. Some boys had came one day and made me sign a piece of paper. London APP has submitted that PW1 Anil Chandrakar has turned hostile as he is contradicting the contents of the FIR lodged by him and prayed that he may be declared as hostile witness. In view of the prayer made by the London APP and the reason given, and on perusal of the FIR lodged by the informant, PW1 Anil Chandrakar is hereby declared as hostile witness.
Where is his statement before the magistrate, the accused persons? Confessional statement.
My lord, page number, my lord, 24.
Page
Page number 24, my lord.
24.
25 is the type copy, my lord. This is 161 is statement.
This is Anil Chandrakar only.
My lord,
The accused person has supposedly made confessional statement before the magistrate.
yes, my lord.
Where
That is there, that is here, my lord. Okay. Ah. Page number, my lord, may kindly. Page number 47. 47, my lord.
Yes,
And
page
the
47.
type copy is 48, my lord. Statement, my lord, is 54, my lord. Page number
No,
54.
48, what did he say?
48, my lord, this is the form, my lord.
Or this is a form?
Yes, my lord. His statement is at page number 54. It says, my lord, while
54.
carefully avoiding anything in the nature of procedure, the measure,
One second.
yes,
54.
yes, my lord.
Yes, while carrying.
Now, my lord, I, Sri Lokam Talo, age about 21 years, son of late Lokam Hani, to state that the complaint lodged against me is a false and I did not ask any money from the MS Infra India Limited, Itanagar, or from any other shopkeeper's person. I did not ask for giving rupees 50,000 or 1 lakh from them. I did not took any pistol or any other arms from Sri Yumlam Achung or other person. Those pistols were of Kochari boy and buried those arms undergone Mr. Chetri, a Maruti taxi owner, told me that those pistols were been owned by the Kochari boys. So at any cost, I do not confess myself. I had do not know a crime is extortion of money at the gunpoint or keeping arms with me. I am quite innocent in this alleged case. Record of
So this is regarding the other case,
no, my lord. This is regarding this case only, my lord.
but there is nothing has been stated on this. These people are not involved. Message Infra India Limited is owned by Anilkar.
Yes, my lord.
Huh?
Yes, my lord. Seven, my lord, it says. A record of statement made Lokamtalo, yes, made in the Hindu language. My name is Lokamtalo. My father's name is let Lokam Hagi. I am by class Christian and occupation businessman. My home is at Moja, so and so. This should be taken on. This is in the this form, my lord. His statement has been recorded. My lord. The bottom part is the form, my lord.
That's all his statement.
Yes, my lord.
There in page 56 bottom, in order to ascertain whether the accused is prepared to make statement of his own. What is your name? My name is Sri Ilham Achung.
This is the statement of one co-accused, my lord. Imam Achong, my lord. Page 56. He was later discharged from the case, my lord.
Yes, then.
So therefore, my lord, in this similar case, my lord, here, of course, in that case, my lord, that they also have placed the order of this honorable court, my lord, where the proceeding was quashed, my lord. Here, my lord, only the difference is that, my lord, there is allegation of this positioning of the arms, my lord. And for that, my lord, no sanction has been obtained till then. And with that, in that regard, my lord, I had
But where is the order that is
That-
lost?
that order. My lord, I had one copy, my lord.
Please give it to me. It is not there on record. Have you submitted last time?
Yes,
No, I don't think the record, my lord. It's not there on record. The Mitali 30, yes, Mitali 30.
That's judgment.
Where is the chapter? What is this? This case law?
Oh, my lord, this is, regarding sanction, my lord.
Which paragraph?
Granting of sanction, my lord. Para, my lord, the para, my lord, relevant para would be, my lord. Para 5. It's short judgment, my lord. Para 5 to 10, my lord. May I read, my lord?
Yes. There are 5 to 10.
Yes, my lord. It's very short in fact, my lord. It is true that interference by the court at the investigation stage did not call for. However, it is equally true that the investigating agency cannot be given the latitude of protecting the conclusion of the investigation without any limit of time. This court is also, while interpreting the scope of Article 21 of the Constitution, held that every citizen has a right of speedy trial of the case pending against him. The speedy trial was considered also in public interest as it serves the social interest also. It is in the interest of all the concerned that the guilt or innocence of the accused is determined as quickly as possible in the circumstances. The right to speedy trial encompasses all the stages, namely stage of investigation, inquiry, trial, appeal, revision, and retrial. While determining the alleged delay, the court has to decide each case on its facts, having regard to all the attendant circumstances, including nature of offense, number of accused and witness, the workload of the court concern, prevailing local conditions, etc. Every delay may not be taken as causing prejudice to the accused, but the alleged delay has to be considered in the totality of the circumstances and the general perspectives of case. Inordinate long delay can be taken as a presumptive proof of,
But in this case, the ground was delay.
yes, my lord.
But in your case,
Now, my lord, in my case also, my lord has seen, my lord. Case, it was registered in the year 2008, statute was submitted in the year 2008, my lord.
2008.
Yes, my lord.
Yes.
The trial started in the year 2022. There is a gap of 14 years, my lord. After trial has started, my lord, till that, my lord. Now it's been more than 17 years, my lord. Within this
Trial started in 2022.
22, my lord. Till that, my lord, they have not initiated anything to obtain the sanction, my lord. Such a delay, my lord, in such circumstances, my lord, the Honorable Apex Court, my lord, has, my lord, passed the proceeding against the, my lord, the petitioner, my lord, in that case, in this case, my lord. My lord, may kindly come to para, my lord. Para 8 and 9, my lord. This is short para, my lord. I read this, my lord. This court in Ramachandra Chaudhary versus State of Bihar and others was the investigation against the accused on account of not granting the sanction for more than 13 years. The facts of the present case are almost identical. No useful purpose will be served to put the appellant at trial at this belated stage. Keeping in view the peculiar facts and circumstances of the case, we are inclined to quash the proceeding against the appellant as permitting further prosecution would be the travesty of justice and a mere ritual or formality so far as the prosecution agency is concerned, and unnecessary burden as regards the court matter. This appeal is accordingly allowed by setting aside order impugn and quashing the proceeding initiated against the appellant on the basis of so and so under the provision of Prevention of Corruption Act. Here in this case, madam, there is a delay of 13 years. In my case, madam, in the present case, madam, till that, madam, there is a delay of long 17 years, madam. After the filing of the charges, madam, at all the investigation
So,
agency, they were interested in
Filing
obtaining.
of the charge sheet took only 16 years, almost.
Yes, madam.
Hmm.
Yes, 2008 it was filed, madam. Trial started in the year 2022. There is 14 years, madam. Now, this is we are in the middle of 2025, madam. So, madam, total years would be 17 years, madam.
Any other grounds?
My lord, since my lord,
See, your first ground is that FIR was not filed by the complainant.
yes, my lord. So therefore, there is no prima facie case against me, my lord. When my lord, the alleged complainant, my lord, he himself,
Second line of submission.
second letter of submission, my lord, is that since the petition has not committed the offense, my lord, as alleged in the FIR, my lord. So therefore, further proceeding, letting the this proceeding, my lord, continue, my lord, by this honorable court, my lord, it will only harass the petitioner, my lord. And
Is there any statement by any witness or any witness or co-accused stating that he is not involved?
my lord,
Is there any statement like that? And what is the stage before the trial court now?
my lord, still this prosecution witness is being, my lord, taken, my
So prosecution witnesses are being examined.
lord, examined, my lord. Since, my lord,
So there is no statement in that regard stating that he was not involved.
no, my lord, at the time of filing this application, my lord.
IO has stated that he is involved.
Yes, I will obviously say, my lord, because my lord has prepared the case, so he will obviously say what is there in the charge sheet, my lord. So his statement, my lord, cannot be, my lord, taken as a gospel truth, my lord. The statement of the complainant, my lord, it should be taken as gospel truth because he says, my lord, I did not file any complaint against Mr. Lokam Talo, who is the petitioner here, my lord. And at that apart, my
And
lord.
you have filed an affidavit by
Yes, my lord.
submitting
That
this-
apart, my lord, even the
Settlement.
wife of the deceased, my lord, this is complainant, my lord. By Yes, even my lord. This short affidavit, my lord, saying that my lord, during the lifetime of his husband, my lord, his husband. Her, the husband told her that my lord, no such offense was ever committed by Lokantala, my lord. So she has shown affidavit to the effect, and we have filed additional affidavit election that.
Yes, that's all from you.
Yes, my lord. Since my lord, there is no charge of this conviction, my lord. Letting the trial, my lord, proceed against the alleged accused, my lord, the petitioner here in my lord. It will only be the harassment to the petitioner, and it will, my lord, not serve anything, my lord. So to save the precise time of the court, my lord.
May not be wasted.
Yes, my lord. So therefore, this application may be, my lord, allowed, and the proceeding against the petitioner may be, my lord, quashed, my lord. As in the similar case, my lord has already seen the order passed by Justice
Yes, yes,
Thakuria Mohan. In that line, order may quash.
May it please your lordship.
yes.
Your lordship, as on the
First
last,
you tell me sanction, why the delay in sanction?
your sanction is still not obtained, my lord. Now,
How much time will take? You want?
no, your lordship, again, your lordship, the question here is, your lordship, the investigation, so far as the investigation is concerned, my lord, it is within the domain of the investigation agency, my lord.
Yes.
Regarding the sanction, your lordship, the investigation authority cannot force any authority to accord the sanction, my lord. The only thing what the investigation agency can do is to place all the material, basing on which they can make a prayer before the concerned authority to issue sanction, so that that person may be prosecuted accordingly against that section, my lord. And now here in this case, my lord,
Why sanction is required? Yeah.
the section, your lordship, the arms act section is involved, my lord. Arms act section is involved. That's why section under section 39.
The answer.
39, my lord. Three nine, my lord.
Yes.
License. No. Sorry. Yes. Previous sanction of the district magistrate necessary in certain cases. No prosecution shall be instituted against any person in respect of any offence under section 3 without the previous sanction of the district magistrate. Section 3, my lord, speak about, your lordship, license. Without license, no person can use, possess, alter, fire ammunition or firearm. There is 3 is the license for acquisition and possession of firearm and ammunition, my lord.
Yeah, so let me understand like why this sanction is actually required. Somebody is not using, and yes, asking it. What is the object and the purpose behind taking a sanction?
Your lordship, the object is, your lordship, if a person, supposedly, if a person has been given a license, proper license, my lord,
Then
in that case, your lordship, sanction is not required. Why? Because the license itself clearly established that, okay, the authority has given you license, because for obtaining the license also certain procedures are there. The whether that person is in is capacity to possess, your lordship, firearm or not. So considering all that aspect, your lordship, license is normally issued. Certainly bond has to be signed, everything are there.
is it only to find out whether license is there or not? The sanction thing.
Yes, your lordship. If in the indirect way, your lordship, it is sanction section 39, your lordship. Normally, when application is made before the concerned authority, magistrate, for want of sanction, then magistrate, your lordship, what they usually do, your lordship, they make an inquiry whether any license has been issued to this person or not, and against that firearm. Because, my lord, I may possess the license, but I may possess the firearm which are not under the license also. So, the concerned investigation authority will make an application by producing all the relevant document, and he will make a prayer that sanction may be accorded to prosecute him under section so and so, because he is not possessing any license. Because, Your Lordship, the accused will definitely get an opportunity to produce the license,
Behind the sanction is
to find out whether he's authorized.
authorized to carry the license.
Yes, exactly.
So
Yes, and second part is, my lord, even if he is authorized, sanction is not required, but that he will be in contravention with the condition of the license. For that, he will be prosecuted, and for that, sanction is not required. That is there. And, Your Lordship, so far as, Your Lordship,
so basically the fact finding exercise of whether he is possessing a license or not, that is not yet concluded.
yes, Your Lordship, we have the investigation agency has filed it before the concerned authority. Now, here in the, Your Lordship, the statement, Your Lordship, is all, Your Lordship, is there in the statement itself, Your Lordship, the statement of the IO, Your Lordship. And no specific, Your Lordship, document to that what kind of application was filed, but in the charge sheet during the course of investigation for sanction, the IO has applied before the concerned magistrate, madam.
The IOS statement was made in, this statement was made in 2024.
Your Lordship will find in page 22 also of the charge sheet, my lord. The prayer for prosecution sanction has already been submitted to the magistrate.
That I have seen earlier, but
Yes.
in the deposition where deposition, I did not collect the prosecution sheet.
Or receive, my lord.
He stated that I did not collect prosecution sanction against the accused person. The concerned district magistrate for proceeding against him under the said answer. Although I had made a prayer for prosecution sanction from the concerned district magistrate, I did not receive or collect the said sanction from the district magistrate.
Yes. That is there, Your Lordship. He stated that he has not collected.
His job is completed. He has sought for sanction and he slept out.
Yes, that is
He
there.
did
Your
not
Lordship.
collect.
Yes. But, Your Lordship, the question here is again, my lord, we are in a case where this court.
As far as arms act is concerned, it's a statutory provision
Yes, Your Lordship.
that we'll have to take in
Yes, Your Lordship.
to prosecute something.
Yes, Your Lordship.
Now, of course, there are some additional sections are there, but the arms act is also involved.
Yes, Your Lordship.
We have not taken prosecution sanction also. Then how will you prosecute him?
Your Lordship, that is no doubt the defect on the part of the investigation agency, Your Lordship. That is there, Your Lordship. But to that extent, for other, it will not have bearing on the other section for proceeding to take cognizance or proceed further.
Yes.
Now, here in this case, Your Lordship, what my Your Lordship limited understanding so far as the power under 528 is concerned is, my Lord, whether the in many occasions, Your Lordship, the 528 is a wide power, and wide power with more power has to be exercised more, Your Lordship, cautiously and with circumspection, my Lord. Now, Your Lordship,
Yes, we carry on.
the FIR, Your Lordship, here in a case, the FIR clearly disclosed the commission of cognizable offense, my lord. And FIR was filed long time back in the 2007, my lord.
Yes.
And in between, no application was filed before this court challenging that FIR, that this FIR was never been lodged by that informant, my lord. The first part, my lord, I'm just going on the fact, Your Lordship. And second part, my lord, during the course of the investigation, Your Lordship, the firearm was recovered, my lord. It was seized. No doubt, Your Lordship, sanction has not been obtained because there is a defect on the part of the investigation authority. No doubt, Your Lordship. But, Your Lordship, so far as the charge sheet is concerned, Your Lordship, the requirement of charge sheet is fulfilled, my lord. The statements were recorded, the seized document and seized item will be made the part of the case charge sheet, my lord. And it was subsequently submitted before the magistrate in the year 2008. Police has done their part, my lord. But so far as the Arms Act is concerned, the sanction is concerned.
It says done their part means.
They have done their part in the sense, my lord,
2006.
on 2000,
They filed the charge sheet in 2022.
2008, my lord.
2008.
Yes, Your 2008, not 22, my lord.
Sorry, sir. What
22 trial started.
But on a trial, why the trial started so late?
That is in the part of the judiciary, my lord. Judicial part, my lord. Because the investigation authority do not have
But there
control.
may be some reason.
Maybe reason, but your lordship, they have not stated that reason. They are only alleging us, your lordship.
That
You are-
don't have any idea.
The charge sheet was filed long time back,
Yes, long time back.
and trial started in 2022,
Yes.
24,
22.
22. It's quite surprising why it took so many years to start of the time.
At that point of time, perhaps, my lord, the judiciary was not properly separated also, my lord.
But that shouldn't be a reason for like.
Yes, but your lordship, that part, your lordship, no doubt, for Arms Act, your lordship, yes, there was a bar for the magistrate to proceed further. But for the other sections, the magistrate has later on proceeded, my lord. And your lordship, so far as the charge sheet is concerned, your lordship will find there is sufficient material under no stretch of imagination, your lordship, anyone can make that yes, no offense has been made out, my lord. Then your lordship, the power of 528 comes, yes.
So many years, what purpose will be served?
Your lordship,
And the other case is cost.
your lordship, that is also,
See, other case also for similar offense.
my lord, we are only your lordship, the other aspect has also been looked into. The antecedent, the person is involved in the other offense also. This is not only this solo.
Yeah, as far as the record is concerned, two offenses, correct? One is the instant case, the other one is that other case which has been already quashed.
This only because they have brought.
There only one thing is that there's arms was not involved.
Yes.
Arms act was not involved.
Yes, your
That's
lordship.
what I was saying.
Yes, your lordship.
Thing is same this thing.
Yes, extorting money, extorting money from the others, your lordship. But this, your lordship, no doubt, your lordship, in the Mukesh case, your lordship, it has been held by the Honorable Apex Court that no doubt the court is not only to see that, your lordship, no innocent person be punished, but also to see that guilty person does not escape, your lordship. So now here in this case, what I'm trying to submit is, my lord, FIR disclosed cognizable offense, commission of cognizable offense.
But it was denied by him that FIR was filed by him.
But after how many years, my lord? That is also one of the aspects. And second part, my lord, after his death, wife is giving a declaration, and that cannot be taken as a sterling one because it has not gone through the rigor of the cross-examination, because that statement was never been given before the trial court, my lord. They are just coming with an affidavit, a non-judicial paper, and that has not gone through the rigor of, your lordship, cross-examination before the trial court. The prosecution has not given an opportunity on that. And now, your lordship, the second part is whether the material whichever has been collected basing on the commission of the cognizable offense, that can be diluted merely because, your lordship, they has done hostile and come with a statement before the court that the statement was not, FIR was not lodged by him, my lord. In fact, your lordship, interfering at this stage will be amounting to acquitting the accused by this honorable court, exercising 528, my lord. Now, your lordship, what my humble submission is, your lordship, if there is a delay, there is a matter of convenience also, because they are saying that I am unnecessarily harassed, your lordship. So in that case, your lordship may direct or expedite the trial, and your lordship either let it be leave it to the trial court whether either he will be acquitted or convicted, my lord. But your lordship, how, your lordship, the statement given during the trial will have bearing on the FIR or the charge sheet or the material whichever has been collected, my lord.
How are you going to distinguish this other case passed by this court, the coordinate bench?
My coordinate bench, your lordship, in coordinate bench, your lordship, the offense, your lordship, otherwise I have objected, my lord, on that case. My objection is there.
Objection is there. But
Yes, your lordship.
Now, see, your objection is there, objection is recorded. Now a judgment has been passed.
Yes, your lordship.
Now, how are you going to distinguish that judgment?
From here, your lordship, with this case, my lord.
Case?
There, your lordship, the section involved was 511, my lord.
Yes, 511.
Yes, your lordship. Now, the
Yes, 511, yes. And here?
here, your section, your lordship, till charge sheet arms act was there, but not proceeding under arms act, but other sections is 506 and
384 and 511. 384 and 506.
Yes. Extortion, my lord. Five 84 is punishment for extortion, and 506.
511 is punishment for attempting to commit offences punishable with imprisonment for life. Or
Yes.
other imprisonment.
Yes, your lord.
So it is for life. And 506,
384 punishment is down extended 3 years, my lord. By 384.
384.
IPC, my lord.
Yeah, 506 is for 2 years only.
Yes, and punishment for extortion is 3 years, my lord.
You see, one is like criminal intimidation, 506.
Yes, my lord.
And another one is 384.
4.
384.
This is my lord,
384.
3 years, my lord.
Yes.
Punishment-
Now, your lordship,
So the
again,
offences are of lesser than this.
yes, your lordship.
500.
But your lordship, here, the difference here is one, the matter which has been considered by the coordinate bench, there your lordship settlement was taken into consideration because it was filed jointly. Your lordship will find defect of the case that they have jointly filed.
They have
on-
jointly filed the petition.
Yes, my lord. But here they are on merit, your lordship. On merit, even for the cognizable offense, your lordship, if offense is made out, non-cognizable offense, if offense is made out, your lordship, in complaint case, the court may refrain itself from interfering, my lord. But that was settlement.
See, Mr. Ete,
Yes, my lord.
if you have the copy of the coordinate bench's judgment, in fact, the coordinate bench hasn't discussed about the joint petition or whatever. It has discussed, it has been disposed of on merit. You have a look, you have a look. Coordinate bench has in fact not discussed about that joint, the fact of joint application or like whatever. I'm not saying this is binding on me.
Yes, yes, your lord.
But
Your lordship, here also, your lord.
But thing is that this offense occurred at the same point of time.
Yes, your lord.
Sometime in and around.
Yes, your lord.
Correct.
Yes,
And like the allegations were also same.
yes,
Other than the arms act, the allegations were same.
yes, your lord.
The sections were different, of course, but
Yes.
sections were in fact lesser,
Yes, your lordship.
of lesser gravity.
Except your lordship, arms, yes. But your lordship, now, your lordship, my only concern is, your lordship, since this is not a matter of, it's not a settlement, my lord. Otherwise, in this kind of cases, your lordship, if,
No, settlement is one thing, but like he's arguing on merit also.
yes, on merit, your lordship. Now, here the question is whether the section are attracted or not. This has to be looked into, my lord. Whether the sections are attracted, whether it is just for the namesake, it has been incorporated, your lordship. Otherwise, your lordship, if cognizable offense is disclosed, as your lordship, on last occasion, I have now I don't have the copy. The Aryan Khan matter and the Supriya Jain matter, my lord.
Yeah, that we have.
Yes, your lordship. There, your lordship, it is clearly stated that your lordship clearly held that if FIR disclosed commission of cognizable offense, and then your lordship, the courts normally courts should not, your lordship, interfere, your lordship. And your lordship, while exercising power under your lordship 482 or 528, my lord, the court cannot hold mini trial, my lord, or see the veracity of the allegation, my lord, the correctness of the allegation. Here is a case, your lordship, FIR till charge sheet, everything is fine, my lord. So far as because the material clearly disclosed that the cognizable offense has been committed, my lord. But only the second part is after trial, my lord, they turn hostile, and then your lordship, basing on that, they come before this honorable court. And your lordship has seen the statement of the IO also, my lord. The why IO, these are matter, why I'm saying so, my lord, this is matter to be raised before the trial court. Why IO will wrongly implicated a person? These are the matter of trial which they have to be crossed before the trial court, that why are you wrongly file an FIR against a person where the other person has not stated.
This court has to look into all aspects of it.
Yeah, that is there, yes, sir.
This offense occurred in 2006. And the offenses committed are punishable only for 2 years and 3 years. Now, after so many years have passed, now again he will face trial, and this is not his fault. The prosecution should have started the trial or whatever, that the charge sheet they have filed, of course, that is fine. But probably there was no push from the prosecution side also regarding this starting of the court. I mean, the starting of the trial in the court, because somehow it was lying like that. After so many years, the person will be again pushed to the trial. Those aspects has to be also looked into.
Yeah, that is there.
I'm not saying that
My lord.
I am giving an opinion on the matter.
Yes, your lord.
That has to be examined also.
Yes, your lord.
This aspect has to be looked into.
Yes.
And it's a petition under 520.
Yes, your lord.
28.
Yes, your lord.
So we'll have to do this justice.
Yes, your lord.
Looking into all the aspects.
Yes, your lord.
So
So, my lord, the other aspect, why your lordship making submission on this kind of case by the prosecution, we have to look into the other aspect also, because your lordship, if in this at this stage, your lordship, stage has to be looked into.
and your see how casually your IO has stated.
So far as
He
this,
submitted these things have prosecution sanction, but like he hasn't collected it.
yes, your lordship.
So he hasn't gone to find out whether he has received it or not. So somebody has to come and really hand it over to him. Okay, this is the sanction. You go ahead now. This is not the way to.
Yes, it is defect on their part, your lordship, no doubt, your lordship. But I am on the, your lordship, the other aspect that the proceeding before the court. My, your lordship, only concern is if your lordship in this ground that okay, after prosecution witness has been lead to some extent, and you find that there is no material or everybody turn hostile, then whether that can be a ground to quash the or absolving the accused from the offenses which for on the basing on the FIR, where the cognizable offense has been disclosed and material was so collected, but only during the trial, everybody turned hostile, whether that can be a ground for quashing the matter, your lordship. I'm on that aspect, my lord. That,
You show me some law that I can't do.
my lord, the judgment, the Supriya Jain and Aryan Khan, I have shown it, and other judgments are also there. Wherein, your lordship, I have not come across, because on the last occasion,
See, if you do not have any witness, and all the statements of the witnesses which have been made in the before the police, under 161,
yes, your lordship.
are being contradicted.
Yes.
During the trial,
Yes, your lordship.
then what is to be done?
Acquittal, my lord. If nothing made out, then acquittal, or if made out, then conviction, not the quashing, my lord. That is what I'm trying to submit, my lord. This, at most, your lordship, what I can pray before your lordship, can direct to expedite the trial. A time bound may be given. Let him come unscratched, your lordship, before the trial court. So, your lordship, but this is according to
If it is acquittal only, why the trial should proceed?
your lordship. Trials already
Pending
proceeded.
time, judicial time.
Already proceeded, my lord.
No, trial is not complete as yet. So why should that remaining part also go?
Your lordship, that is what I'm saying. That after your lordship, the stage what I'm trying to say, your lordship, in Lakshmi Narayan case, actually, I have the judgment also, but Lakshmi Narayan is no doubt on the settlement also. Even in settlement, your lordship, the apex court has held that after commencement of the trial, my lord, normally the court should refrain from interfering it and give it the opportunity to the trial court to decide for either acquittal or for the conviction.
Rather than allowing some out of court settlement.
Sorry, my lord.
Rather than allowing some out of court settlement. That's what you're saying?
Because your lordship, stage of settlement is also been, your lordship, discussed by the honorable apex court. Your lordship, my only concern here in this case is, my lord, if I'm not saying my lord cannot do it, my lord have a absolute power yes, your lordship. But my only concern is, my lord, if during the proceeding, when trial commences, your lordship, when the trial court has a power, and your lordship, the material has collected, no doubt the prosecution is not in the position to properly cross-examine whatsoever is there. But your lordship, that result should be either should be given, trial court should be given given an opportunity to take up that matter, and it should be either laid in acquittal or the conviction, my lord. Because, your lordship, the presiding part, that is the FIR or the charge sheet, that doesn't support their case, my lord. That is against them, my lord. But only, your lordship, during after commencement of trial, no doubt that is very vital. There, your lordship, they turn hostile, and on that, basing on that, your lordship, they are coming on the ground that the FIR was also not lodged by them, and on the basing on the declaration by the wife, who is not the part of the prosecution, who has not the witness in the case, they come with the case, and that
Everything was ultimately government. When it came out, then only they can come with something, no? Because nothing was happening. Then trial started. Then they got to know that this person has contradicted his own statement. Then only the cause of action will arise and they'll come to the court. In between, why they will come and say that like, oh no, the FIR was not filed by him and like now.
that is there, but, your lordship, my submission is only confined to the whatever judgment or the authority I'm come across, my lord.
Correct.
Because that part, your lordship, on that part, even I have tried hard to find out whether if during the trial, if no material has been found against the accused, then whether that can be a ground for quashing the FIR or the charge sheet, your lordship. As on that, I didn't come across that judgment. So, basing on that only, your lordship, on the settled law, I'm just submitting that cognizable offense has been disclosed, investigation done, and if FR was not filed, it was a charge sheet. Material were arms were recovered. If arms was not recovered, then situation would have been different. But arms was recovered. But for want of sanction, it cannot be proceeded under Arms Act. For other section, there was no bar, so it was proceeded. No doubt there was a delay. But so far as other section is concerned, the investigation authority has filed it. There is a delay, but not that much delay. It cannot be considered an inordinate delay, my lord. On 2006, 7 investigation complete on 2008, then charge sheet 5. But only that part, my lord, that subsequently, if the prosecution witness turn hostile, whether that can be a ground for interfering with the entire earlier proceeding, FIR or the charge sheet, your lordship. That is the only issue. What I am, your lordship, I am visualizing that this is the only issue here in this
This is
case.
the only ground he's arguing. That's what you're saying.
Yes, your lordship. Whether they have any judgment to show that, okay, after commencement of the trial, also the court can exercise the 528 power to quash the matter if nothing comes up in the prosecution, from the prosecution side, your lordship. Only that.
Heard Mr. Tambuk, learned counsel for the petitioner. Also heard Mr. P. Ete, learned APP. Hearing concluded, judgment reserved.
My lord, kindly allow me to submit one judgment matter regarding this coordinate decision, my lord.
Sorry,
Coordinate bench decision judgment, my lord. That I will be submitting, my lord.
whether binding or not binding?
Yes, my lord.
That is fine. That is we are aware of. Okay, you can submit it, but see, coordinate bench, usually this decorum is that you should maintain that.
Yes, your lord.
But if you find like something which is drastically different in your view,
Yes, my lord.
Yes.
then of course we can go.
Distinguished also, yes, your lord.
And it obviously gives a very, I mean, it gives a guidance kind of.
Yes.
Like decorum should be maintained. So if you have something, you can give it to me, but I'm fine with that. I'm aware of this.
Then, my lord.
Oblige, your lord.
Item number 7.
My lord, this year has not been received yet, your lord.
Mr. So-and-so, then counsel for the applicant is present. Learned, Mr. T. Ete, learned APP has submitted that this year was called for. The same is yet to be arrived. What was the date? Yes,
think not any.
We will not direct for, I mean.
Yes, TCR has to be called, but it was not direct. On
No, no,
21,
the PCR was directed,
Yeah.
or it was only on 6/8/2025. So we'll wait for some time.
yes,
Hmm?
yes.
PCR is awaited. Least this matter after 2 weeks.
Oblige. Oblige, Your Lord.
Item number 8.
Yeah, Lordship.
CD was called for.
CD was called for, Your Lordship, without taking much time, Your Lordship. There is, her custody is not required. Her custody is not deemed required, Your Lordship. The allegation was, Your Lordship, actually the husband has lodged an FIR against the wife with the allegation that she is drawing salary from two department from different district, my lord. So her statement was recorded, and later on, Your Lordship, even the husband had stated in his statement, and wife has also stated that later on they have made this complaint to the concerned authority, and it was discontinued, Your Lordship. And for that, the material whichever has been duly collected by the investigation authority, Your Lordship. So for that, Your Lordship, in my humble understanding, Your Lordship, her further custody detention is not required.
Lordship, this is in cases where Lordship, with malice and with vengeance, the husband has lost an FIR against me.
It's a marital dispute, then.
In fact, Lordship, here I had a lodge FIR against him, but with connivance with, I would say, with the investigation officer.
So I'll allow this.
Yes, Your Lordship, CD is with me, Your Lordship.
CD just.
Yes. The statement I have marked, Your Lordship, complainant statement and the accused statement to serve there.
You please write down the names, and order will be dictated later. Item number 8, right?
Right.
Shall pass the order.
Deeply Lordship, about the bail bond,
It will be yes, bail bond, how much?
Lordship, with like security of 5,000, Lordship.
5,000 is too less.
Too less. At minimum 20,000 at this moment.
Bond 15,000?
Yes.
And then like security also. Security also, and the normal conditions, nothing hers.
Item number 9.
CD not received.
CD not received, my lord.
What is this additional affidavit?
Additional affidavit, the previous order passed by the learned session court.
Rejection
The
order.
rejection order.
Learned so and so appears on behalf of the petitioner. This filed today.
Yes.
The applicant, not petitioner, right? Applicant. The applicant has filed an additional affidavit today in this matter, bringing on record the order dated 24/7/2025 in bail application number 341/25 in ITA WPS case number 40 of 2025. Passed by the Sessions Court, passed by the Court of Session Judge, UPIA, whereby the applicant's bail application has been rejected. Affidavit is kept on record. It is submitted by Mr. P. Ete, learned APP, that though CD was called for, CD is yet to be arrived. He is sitting for 2 weeks time to
Yes, Your Lord.
produce.
One week. Because it was filed, application was filed way back earlier. Your Lordship.
Okay, your lordship, 1 week, I can handle.
No, it was, the order was communicated on 18/8 only.
Yes, your lordship.
You can note it down as per the, from the note sheet. It is seen from the official note that order dated 13/8/2025 was communicated on 18/8/2025. To the letter heading. Let the matter be listed after 2 weeks.
Okay.
By that time, the learned APD will produce
Updated case diary.
the case diary,
Yes.
the updated case diary.
Deeply obliged, man.
Item number 10,
We have not taken place.
We are.
Mr. Tabit Tapak appears on behalf of the petitioner and he submits that though fresh tapes, though there was a direction from this court for taking fresh tapes for service of notice, he is yet to procure the correct address of the respondent number 1, respondent 1 and 2.
Where, 1 and 2.
Respondent numbers 1 and 2. Therefore, he prays for 2 weeks' time to take fresh steps by way of register, to take fresh steps by way of registered post as well as unusual post. Prayer is allowed. Place this matter for 2 weeks.
item number 11,
Objection not filed.
I am the petitioner.
My lord, we have an objection to the IA filed by appellant.
So we haven't filed it.
I'm checking for 2 weeks period for file a
We
counter
are
appeal.
appearing for whom?
Lordship, we have given a sufficient time for filing of objection.
You are appearing for whom?
Sorry, my lord.
Hmm? You are
Appearing for appellant respondent on behalf of R. Ingo.
Huh?
On behalf of R. Ingo, I'm for respondent.
You are for respondent. Which respondent? All
All,
the respondents.
all respondent.
Learned so and so appears on behalf of all the respondents. Respondents in the IA. This order is also passed in IA. No? Respondents in the IA. He prays for 2 weeks' time
Yes.
to file the objection
My lord,
to the,
1 week is enough.
to the ISO file. To the ISO file by the pitch. ISO file by the applicant. Prayer is allowed. Release the matter after 2 weeks.
Obliged, man.
Obliged.
In the main also, you'll have to pass a order, the same order. The RSA. Is RSA number 01 of 2025. The order was in IA, so you pass this on RSA also.
item number 13,
May I please, Lordship?
What is this? This is item number 13.
Yes,
Affidavit by Dustin and file.
yes. Service has already been completed.
Hmm?
Service is already completed, Your Lordship.
Okay.
Yes,
We haven't filed affidavit.
yes, we have already filed the affidavit. Yeah.
But the office note says affidavit not filed. It is not in record.
But in the last occasion, we have already filed, Lordship.
It will file again. It will file here. Yeah. No, baby. Affidavit is not on record. Office note also says there is no, I mean, Mr. So and so, you check it and like you file it. You have to file an affidavit that you have served Dusty,
Yes, Lordship, we have already filed it, but
but it's not there on the record.
okay, I'll make sure that,
You check it and like if it is
Yes.
not on record, you bring on record.
yes,
Correct.
Lordship,
And if you have not filed, then file it again.
Lordship, a fixed date may also be given because, a fixed date may.
Fixed date, how can I give fixed date? We have not filed the affidavit.
I'll get it filed by
I'll not.
evening on.
There's no point giving fixed date. We haven't filed a affidavit for single. MS so and so appears on behalf of the
Petitioner.
petitioner. And she pays for. And she submits that an affidavit has been filed for service of the stay. Which date? You remember the date?
I don't remember the exact date, but we have filed already. Lordship.
Submits that she has filed an affidavit with regard to the service of the stay, but the same is not available in the records of the case. Seen the office note dated 28/2025, wherein it is stated that affidavit is not yet filed for service of the stay. For justice service of notice upon the respondent number 125 by the learned counsel for the applicant.
Lordship,
Let the matter be fixed after 2 weeks. For filing, for bringing on record the affidavit so filed for service of the state. After 2 weeks.
May please, Your Lordship. Lordship, I would like to make a small request, Your Lordship. In item number 19 and 20, Your Lordship.
19 and 20 years.
I'm the PP in this matter, Your Lordship. Lordship, I'm not feeling well now. So my senior has, in fact, this matter has come on many occasions. So if he's ready, he'll be doing the matter tomorrow. If Your Lordship just reserve my argument for tomorrow, Your Lordship.
My lord, we can have part heard.
Let her be present, she's not feeling well.
Uh,
We can have it the next week sometime here, next,
my lord, this matter has been pending since last 2 years.
there is a hearing.
He, yes, sir.
Ah.
He
You can hear it,
the convict is in the jail, my lord.
Hmm.
So I want to get this matter disposed of as early as possible. Since he is also allowing me to make argument, but your lordship may have part heard. By tomorrow, she will argue her part.
all we know, see, it will be better both the parties are there. She is not feeling well.
But sometimes what happened,
But you are, but then tomorrow you'll be there or not?
I'll be there.
So you'll be there tomorrow also?
Well, in many occasions, this thing had happened. Since the matter is always listed in the latter part of the codice, so it could not reach my. Since we may have to have time today,
But tomorrow we can have it like as a past item in the hearing.
first item. In that case,
In the hearing.
no, melody. Even then, it
The
may
first
not.
time- but
It may
the
not.
Past item hearing, if I take the whole day will go, then other matters will be left out.
Then let us have part of matter. That would be the best,
Keeping part is not, it agree.
because even if we get the matter listed tomorrow, we may not have sufficient time to dispose of the matter.
Tomorrow is like, this thing, no? Today is hearing day, tomorrow is a miscellaneous day kind of here. That is what we are, I think we have been maintaining here. So tomorrow your matter may be listed as a past item in the hearing. Then you can argue. No, I can go ahead, there's no problem, but it is always convenient, no, because she is there, she will not be there, she may require to point out certain things and see that will be left out. And she'll not be here. She's not feeling well. I can make out from her face.
Yes, I know she's having some problem. But she's also saying that I may argue my part.
No, I think like we'll take it up tomorrow.
Uh,
It will be listed as first item in the hearing. I will take it, we'll take it up.
all right.
See, usually what is happening, the trend here is that division bench doesn't take much time.
Hmm.
Usually by 1 hour, division bench is over.
Mhm.
Then I sit singly.
Hmm.
If the single, I mean, if there are some matters also,
Hmm.
then hearing can be taken at least second half. By second half, I think we can start. If a matter is listed as the first item in the hearing.
All right.
Column.
All right. No problem. As pass item in the hearing.
First time is it?
Yes.
After finishing other matters, we will quickly go to the matter and hear it.
All right.
Right, Mr.
S. Koyang.
Mr. S.
Koyang.
Mr. S. appears on behalf of the petitioner. Mr. Jimmy appears on behalf of the respondent state. Mr. Jimmy submits that she is not feeling well today. So she is not feeling well today, and therefore she says that the matter may be listed tomorrow for hearing. This matter tomorrow for hearing. Here as a first item in the hearing column.
She is representing victim. Victim. No. 376.
Mr. So-and-so appears on behalf of the informant. If respondent what you? Respondent method. This matter tomorrow as the first item in the hearing column. Okay.
All right.
Item number 14.
Your Honor, I'm for the appellant as an LS, Your Honor. Your Honor,
There's a IA.
yes, yes.
Notice hasn't been issued yet.
What is that?
Notice was not issued.
Lordship, this is the jail appeal lordship. Last occasion lordship, the court had directed to appoint legal aid counsel lordship by the registry. So now he is
She has
appointed.
been appointed as
Yes,
legal
yes,
aid counsel.
yes, lordship. So notice may be issued and lordship, here,
So then you are appealing for the
Appellant.
appellant. So this is your this thing.
IA.
IA.
Yes.
For this.
For
No
competition.
objections is that.
no, I am no advisory, it's a condonation lordship.
Condemnation for 7 months.
7 months.
No, so it's okay because the jail appeal, so it may take some time lordship.
So I will dispose of the IA.
Yes, lordship.
And
And call for the records lordship.
and is there any application for stay of the award?
No, stay for no application lordship, only condonation. of the-
So and so. Your name, please,
Obingit.
who has been appointed as amicus curiae for the appellant. Amicus curiae in the matter to appear on behalf of the appellant is present in the court. So, this. Agree.
For state lordship, one.
Forgetting the names, I have two properties.
Actually, Lakshmi Hage actually. Yes, lordship.
PP appears for the state. So, that was how they submit this, it doesn't have any technical thing. Allowing the PP is under section 5 of the minimum payment for commitment can delay of 7 months. Accordingly, RV is allowed disposed of. The main appeal, right? So and so present. Admit the appeal. All for notice, raised to the call for notice here. Is this matter of the province? There's no other respondent.
No. Just the paper book may be prepared also.
Paper restitute is there. The paper book. And keep it ready. Keep it ready by the next day. Listen.
That's okay.
You have the copies, no? Copy has been submitted.
No, sir, the paper book will be.
Paper copy given to you, but
Yes,
like,
sir.
okay,
The
fine.
copy is also not applied.
Item number 17.
May I Lordship, I am appearing on behalf of R. Raksa, the counsel for the appellant. Since R. Raksa is out of station,
He's out of.
yes, Lordship, and
Sorry,
he,
he's out of station.
moreover, he's on letter of absence. This matter may be, Lordship, as instruction on instruction, this may be kindly fixed on 4th September or 11th September, as
Mr. So and so appears on behalf of Mr.
R. Raksa,
Alexa, the
Ca-
counsel for.
appellant.
The appellant. He submits that Mr. Alexa
R. Raksa,
is
out
out
of,
of station,
yes, Lordship.
is out of station. He prays for distinguish the matter on
4th of September.
4th of September.
Yeah, I'm appearing for the, Your Lordship, the Government Advocate Council. Why Ram, my lord?
Please write to Mr. P.A.K. appears for
Why Ram, Junior Government Advocate, on behalf of Your Lord.
on behalf of him.
Yes, ma'am.
And he doesn't have any objection if the matter is stayed on 4th of September. Or will release the matter on 4th of September.
Deeply obliged.
Deeply obliged.
Item number 18.
Yes, Mr. Kara.
My brother Murtoja has been coming from Basar, and there is a pressing need for him to dispose of this matter. So we'll make an endeavor for disposal, my lord. Yes. Now, my lord, just I'll outline a little bit. 26/12/1977.
Yeah, 1 second. The pleadings are complete. No?
Pleadings are completed. After this, I'll refer to one judgment by Justice
Justice.
Fukan. So that will cover everything. Just you take this.
So Mr. Tara is appearing for,
I am for the petitioner,
here for the
civil revisionist. My lord, on 26/12/1997, the father of the petitioner number 2 purchased a plot of land. Thereafter, what had happened was some dispute arises. And then thereafter, my lord, there was a blaze label kava held on 30/4/1997. There, what had happened was on dated 30/4/1997, evening at Gori village, the village authority, after proper discussion and verification of the matter, has decided a case as under Sri Yadav Basar shall retain and cultivate his own portion of WRC field as earlier. This land, as claimed by Sri Nyajum Basar, was not totally fully purchased by Sri Nyajum Basar, that is father of the petitioner here. Harnya Basar has given one mitun to the seller as per consideration of the purchase plot. Therefore, Sri Yadav Basar cannot be disposed from his portion of WRC land. Sri Yadav Basar shall sacrifice a cow for Sri Nyajum Basar on the days to come, and also to give some brass ball, brass kahibati in Assamese we call it. So now that has happened, and this particular Kava decision has attained finality. Not challenged by either of us. So now thereafter, my lord, what had happened is, after almost a gap of 20 years, my lord, on 15/5,
And like And both of you were occupying the land
Yes,
in your possession.
in our own possessions,
For this Kaba
as per this covenant. Basically 2 bighas by me, my grandfather. Then my father. Then, my lord, what had happened after gap of 20 years, 15/5/1997, that Lords will find in page 30 of that Kaba decision. So this Kaba decision was held. So there, finally, the English version, my lord, will find is at page 31. I read out that
You're
English,
talking about the Kaba decision that was taken place at that point of time.
that point of time. Now, second Kaba was held.
Second Kaba, why it was held?
The saying that
First Kaba is at page what?
first Kaba is at page 28. my lord.
Page.
Yes. Yes, I'll indicate, my lord, that's.
You can narrate the facts very easily. Then
Yeah.
let me understand that
Then,
because Kaba decisions and all these judicial these things are new to me.
I understand, my lord. See, then what had happened was the respondent started claiming the whole WRC field.
Now, you tell me why this second?
Yeah, second Kaba, after 20 years, she filed this Bango level Kaba.
Who has
The respond.
okay, he has filed.
Yes,
He has filed some kind of decision before a Kaba.
yes, yes.
Okay.
So then what had happened was, here the respondent claimed whole WRC field. So saying that which the petitioner father did not allow him to do so, and then made this complaint before the sub-divisional officer, saying then thereafter it was decided in this way, my lord. Then the SDO Pasar passed an order directing GBs of Gori Blaze to conduct a Kaba on 30/4/1997.
One thing, I'm sorry for interrupting you. I mean, after the Kaba decision, it is applicable before the state subdivision.
Yes. Earlier it was under section 46. It was there. Now it has been amended. It has been amended, and then
Now who is going to power?
now the district,
District court.
junior division, then senior, then this thing. Appeal this.
Earlier it
In-
was like from the Kaba, they
Yeah,
had to go to
yes.
subdivision officer.
Yes, yes, no. So then what had happened? It was decided that both the party in this, they will retain their own respective plot of land.
As per the decision the earlier Kaba.
Earlier, the secondly also that way. my lord. Now, what had happened is, my lord will kindly come to, then against this, the father of the petitioner, the second Kaba, the father of the petitioner was aggrieved by this decision. No, if this 1977 Kaba has attained finality, then why this second Kaba should take? So therefore, this came into, and then he filed this appeal at page 32. That was on 16/5/1997. This in form of annexure 4. Yes. Then what had happened thereafter? Then the extra assistant commissioner, we call it as the EAC that point of time. Now it has been rechristened as assistant commissioner, the lordship. So now then, that's after 17 years, again, the respondent, private respondent, filed an appeal petition after 17 years. That is on 28/5/2014 against the petitioner for violation of Bango level Kaba, reclaiming the title of the land in question. So that is one aspect. Now thereafter, what had happened? The EAC directed for a Bango level Kaba. Bango level Kaba, now Kaba, it is, Kabang basically, my lord, is mostly prevalent in Galo and the Adi community. In Nisi, we call it Nyel or Mel, and the Apatani call it as a Boolean. And
But actually same thing.
no, but this procedure is something very different. Different. But the same thing, but one and the same thing, my lord. But then the procedures, the proceedings are a bit different. Bit different. So then what had happened was, my lord, the Bango level Kaba was held on 16/6/2014, my lord. That lordship will find it, page 34. Then thereafter, my lord, we filed the appeal. We filed the appeal saying that no, this cannot, because you cannot settle, unsettle the settled thing that had occurred in 1977, my lord. So that aspect was taken care of. Then appeal petition was filed, and my lord, that was registered as 138. Basel title. As a 138. And my lord, in one of the proceedings, my lord, just yes, my lord, my order date is 6/6/2025, when the matter came before Justice Nair. Then Justice Nair pointed out the shortcomings in that registration of that particular order. Why this appeal number 138 was registered, and that appeal is not yet disposed of. So therefore, there was a clarification. You have not given me that copy. You have brought.
It is on the record.
Okay, you have not furnished me. That's why I say, give me that copy if it is. So he has filed one IA. He has filed one IA, my lord, before the Basar. Huh? Yeah, he filed one IA before the additional district and session judge Basar and sought the clarification. And then it is clarified, my lord, this appeal was registered as 138 of the Basar title, my lord. So now there is no quarrel on that, my lord. That is settled, my lord. So now, now my lord will kindly come. Page 68, my lord. Now this is from whom the land was purchased, my lord. On 26/12/1970, type copy is at page 71, my lord. On 26/12/1977, I have received a sum of rupees 4,550 rupees only from late Nyajom Basar, the father of the petitioner, for the cost of 3.5 acres of land. My lord will mark this 3.5 acres of land, and per acres of land at the rate of rupees 1,300, only which is located at Kamnya Rike Basar. Further, I have received 1 mitun for the cost of remaining 1.1 acre of land from late Harnya Basar and late Nyajam Basar. So the person who has sold the land is still alive. Is still alive, and he certifies.
He is Miken Basar.
Yes, he's Miken Basar. He certifies that yes, this father of the petitioner has purchased the land by giving 1 mitun and this. So that is no dispute on this. Now, the trouble probably what I find is now this order, page 81, my lord. Now here, my lord, the order was passed by the ADC Basar, my lord. So there it went against us, against the petitioner. And there, my lord, no proper evidence was appreciated. Procedure for the trial was not followed in this.
This
No.
was passed in what? This is passed in appeal.
No, but the complaint filed by us, filed by the private respondent in 2014.
2014, a complaint filed
Before the
revenue authority.
yes, extra, yes. Before that, my lord, what had happened? The appeal was filed, that 138. The appeal was filed by us before the additional district and session judge Basar. Now the judge.
138 under what could be what?
That is under section 46. of the AFR. Under section 46 of the AFR that was filed.
Actually, as they were disputing the.
No, I just want to clarify. You will get your.
Okay.
Only thing is that the 138 was filed under.
46.
446 of AFR.
Section 46 of the AFR.
AFR. Against the.
AFR, that's what I want to see. This is exactly. Under 46.
That appeal against the village authority.
Yeah, this is appeal against the village authority.
Yes.
That was filed before
The
the court of
ADC.
ADC, court of ADC.
Yeah. Then what?
That was registered as 138.
Yes.
Appeal.
Then thereafter, what had happened? After separation of the judiciary, executive from the judiciary, the matter was sent to the additional district and session judge Basar. Now, they have the additional district and session judge Basar has passed that order saying that this court does not have the jurisdiction.
Where is that order?
Just I find out the copy of the.
Now, this order was passed, Mr. Tara.
My lord.
This 11/3/2020, right?
Yes.
This order was passed. And till that point of time, it was that judiciary and executive was not separated.
No separate.
But after this is not the final order.
This is not the final. It is still.
This is what kind of order is this?
This order was passed in the appeal number 138 by the ADC. Against that appeal, they again come before this honorable court.
I'm coming to that now. Then from here, let him.
I just need to clarify one thing. This order was passed when this judiciary and executive separated. Then this matter was placed before the
Additional district and session judge saying that this court does not have the jurisdiction.
which court?
The regular
No,
court. Additional district and session
Using-
judge.
No. Was that the submission or different? That's what I wanted to understand.
I'll just find out.
Is it something like that this ADC doesn't have the power?
No, he has the power. He has the power to hear the appeals, which was arisen out of the customary courts. But in the instant case, Your Lordship, the appeal was from the Bango level Kaba, which was decided in the year 2014. And the Bango
That is also a customary court.
customary court, but it has no existence as per AFR.
It has no.
Existence. Bango level is nowhere in the.
I'm coming to that, but I'll just
That's
clarify. I'm narrating the facts. I have not started anything on the merits or anything. Just I'm trying to give an outline of the. Yes. Just I'm giving this only for the clarifications of Your Lordship only. Is giving a background of the entire case. Then, my lord, what had happened was this. My Lordship has seen order dated 11/3/2020, page 81. my lord.
Yes.
Now, this order was put into challenge by us in page 85, my lord. Every detail is there at page 85, my lord will come there. This is passed by Justice Pukat. So, my lord, can bear with me for reading out this.
Yes.
This is good for him also, for me also, for the court also, my lord.
Okay.
The entire fact is there, my lord. Why we have challenged this ADC order, my lord.
Okay, this ADC order was challenged
Put into challenge under
before Justice Pukan.
Justice Pukan, and that was verdict dated 14.
Okay, correct.
So, my lord will find at page 86. My lord, let us start from. No, we start together, my lord.
Yes.
This civil revision petition under section 50 of the Assam Frontier Administration of Justice Regulation 1945, read with section 151 of the Code of Civil Procedure and Article 227 of the Constitution of India is preferred by the petitioner. Well, that 2003, Lordship will remember on 227, Radhesham Chabi. Yes. And that is passed by the additional Deputy Commissioner Basar and also the order number so and so. The factual background leading to filing of the present petition is briefly stated as the father of the petitioner, namely Nyajum Basar of Gori Village 2, Basar, District Laparada, purchased a plot of Jum land measuring 3.5 acres from one Sri Miken Basar of Gori Village on 26/12/1977. Now, Lordship must be rephrasing. I have given this by executing a sale deed. Yes. Thereafter, in the year 1980, Sri Miken Basar claimed that the father of the petitioner has been occupying excess land sold to him, and thereafter, a survey was conducted and found that the father of the petitioner has occupied excess of Jum land measuring 1.1 acre. Then, as per Galo customary law, the said dispute has been resolved by sacrificing a cow as a community feast, and one male mitun and one brass ball was given to Sri Miken Basar in lieu of 1.1 acre of Jum land. Thereafter, in the year 1997, dispute arises over 1.1 acre of land, and then the matter was referred to village authority, local Keba, and accordingly the matter was resolved once again as per Galo customary law. However, again on 15/5/1997, a second round of Keba purported to be a Bango level Keba was held, in which a decision was arrived at that Nyado Basar, the uncle of the petitioner, shall cultivate 2 bighas of land, which he was already cultivating, and Nyado Basar shall sacrifice any animal and give local brass plate to Sri Nyajum Basar, father of the petitioner, on the ground that both the parties in dispute are brothers in relation and this will maintain cordial relationship in future. Thereafter, on 28/05/2014, Sri Nyado Basar, my lord, here my lord will mark this because this is after 17 years.
Nyado Basar is his client.
His client.
His client.
His client.
And your client is?
Jumli, son of Nyajum.
So you both are the
Cognate, not even agnet.
Huh?
Both of us are cognate only. By blood. So, well, that's, I said 17 years. After 17 years, this lease has come. File complaint before the additional Deputy Commissioner Basar against the petitioner for violation of purported Bango level Kaba order number so and so. In person to the said complaint, the additional Deputy Commissioner Basar issued order number that it's so and so 02/06/2014, fixing Bango level Kaba to decide the land dispute between the parties on 16/6/2014. My lord will mark this order 02/06/2014 order because this has been interfered by Justice Fukan here. Thereafter, Bango level Kaba was held on that day, and a decision was taken there that Nyado Basar shall continue to cultivate a portion of the land, but will not sell the said land without the consent of the family members. Then, being agreed the decision of the Bango level Kaba, that is 16/6/2014, the petitioner, along with his mother, filed a civil appeal number 138/2014 before the learned additional district and session judge Basar. But the learned additional district and session judge Basar transferred the matter to the additional deputy commissioner Basar. You know, that's what I refer to. Therefore, there is no confusion now. Transfer the matter to the additional deputy commissioner on the ground that the regular civil court does not have the jurisdiction under Assam Frontier Administration of Justice Regulation 1945. Thereafter, on 11/03/20, the additional deputy commissioner disposed of the case number so and so without affording any opportunity to the petitioner of being heard, and also without affording any opportunity of cross-examination to the witness. My lord, what had happened was, once Lordship Fukan has interfered with this order, it was sent back to the ADC Basar for fresh hearing with following the procedure. But here, the learned additional district and session judge has not followed the procedure. He adopted his own means, invoking the inherent power under section 151 of the CPC, and then divided the property 50/50.
No, I mean.
No, but I'm coming to this. I'll.
What we have read already.
Yes.
Is that this additional district and session was sent it back.
Sent it back.
Sent it back to the ADC.
ADC.
Right? ADC passed that order in 2020.
20 years.
2020.
Against that,
Against that,
we have filed this civil revision.
against that, we have filed this.
Yes, there what had happened, the error committed by the learned additional deputy commissioner of Basar was that we were not given proper opportunity of being heard, and also the cross-examination of the witnesses. That is, my lord, that is the procedural
The procedural part was not followed.
not followed. Here also, in the impugn order where I am challenging, my lord,
Now ADC has passed an order, we have come against that. ADC
against that order,
Against
against that
ADC's order.
because of not following the procedural aspect.
Okay. Now let's say
Yeah, yeah.
what happened?
Now what then what had happened? The para 3 Milan. Being agreed by the order dated 11/03/2020 passed by the additional deputy commissioner Basa, directing for holding a Bango level Keba, a non-existent forum under AFR 1945 on 2/6/2014, which is barred by the judgment of this court in the case of Registrar General Guwahati High Court versus Union of India reported in 2013. 14 GLT 1109.
So Bango level Keba is not recognized.
Not recognized. No.
That's your version.
Yes, that is judicially held, my lord. So, my lord, what had happened? I just enlightening you, my lord, on what after this, my lord, there's one matter. Now, coming after pronouncement of this Registrar General judgment, now what had happened? The litigants were left formless to appeal against the decision of the Bango level Keba. Now, one case came up. That is called Nabum Nikum versus State of Arunachal Pradesh. It was, that bench was presided by then Lordship Justice B.K. Sarma. So there what had happened, the Lordship's brother, Senior Judge Justice Ete was on the other side, then I was on the other side. So there after listening, the argument went for 3-4 days. So then I made a proposal to His Lordship. I said, my lord, litigant cannot be left at large. So therefore, my respectful submission would be, till the AFR is suitably not amended, till such time, the deputy commissioner shall continue to be the appellate authority. So my proposition was accepted by the division bench. And thereafter that happened, after this subsequent judgment. So that continued for some years, and then that was in 2015 judgment. So that was in 2015 when I argued it. Now, my lord will kindly come to the operating portion at 7.
So that was the dispute, right?
That was
the factual part is that only.
Factual part is
No other factual.
additional deputy commissioner does not have the power to order for Bango level Keba, which is non-existent forum, in view of the authoritative pronouncement made in Registrar General case. That is the
Okay,
case.
so now what was the
Now kindly come to para 7.
para 7?
Yeah, page 90, my lord. Having heard the submissions of the learned advocates of both sides, I have carefully gone through the petition and the document placed on record, and also the impugn order dated 02/06/2014, by which the learned additional deputy commissioner Basar has directed to conduct Bango level Keba, and also the impugn order dated 11/0/2020, by which the learned additional deputy commissioner Basar has decided a matter in favor of the respondent number 2, and also peruse the case law Registrar General Guwahati High Court Supra, and the judgment and order of coordinate bench of this court in WPC 193. These cases are argued by me only. This one of my junior has referred to. I was not there on that day. So, my lord, para 8. It appears from the judgment and order dated 14/9/2019 passed in WPC number so and so that Bango level Keba could not assume jurisdiction to decide the dispute between the petitioners and the respondents, and that only village authority has been recognized as one of the forum for resolving dispute, and except the village authority, the assistant commissioner, the deputy commissioner, and the high court, no forum recognized under Assam Frontier Administration of Justice Regulation 1945 for resolving the land and river dispute between the parties. Now here I am pausing for a moment. There, what had happened? Justice Jamir has rendered one judgment in 2015 on the AFR. So then this has been followed again thereafter. So that I'll at the relevant point of time I'll provide. Now para 9 we need not to read. This is the extract
copy of the para 13, 14, and 15 of the Register General. Now, in para 10, my lord, 10 and 11 is crucial for us. In WPC number so and so, with so and so, a coordinate bench of this court has held that neither the deputy commissioner nor his subordinate enjoys the power to take up dispute of civil nature any longer, and therefore quash the impugn order passed by additional deputy commissioner. This is, my lord, party name is Abu Maj. Abu Maj. That party name I remember now. And another 2017 one. 181 is, my lord, that Nara Meso versus State of AP, my lord. That I remember now.
So these cases were decided when?
This was decided in 24/1 2017 and 28/02 2017 and 23/03 2017, my lord. The next line, it is there, my lord. Now, our case, my lord, here kindly come.
No, what I'm talking about, few orders were challenged in this petition, right?
Okay.
And the writ petitions were decided when?
These writ petitions were decided, my lord, here on
Is it after the separation?
after the separation.
That is why they have to hold that, they have to hold that the commission doesn't have the power.
Doesn't have the power.
That was correct.
That was the correct proposition, yes. I was the counsel in this cases, you know.
No, I think that should be the,
Correct proposition of law.
yes.
So now kindly come to, my lord, para 11. In the case in hand, my lord, see, the dispute relates to a plot of land measuring 2 bighas between the petitioner and the private respondent number 2, as per the Bango level Kaba decision dated 15/5/1997. The respondent number 2 has been cultivating over the said 2 bighas of land, and he has sacrificed animal and given local brass and plate to Sri Nyajum Basar, father of the petitioner. Thereafter, the respondent filed complaint before the additional deputy commissioner against the petitioner for violation of Bango level Kaba decision and Kaba order dated so and so, order number so and so, and thereafter, white order dated 026/2014, the additional deputy commissioner Basar has directed to conduct a Bango level Kaba again fixing 16/6/2014. Thereafter, being agreed by the decision of Bango level Kaba, the petitioner along with his mother filed a civil appeal number 138 before the landed additional district and session judge Basar. But the same was transferred to additional deputy commissioner Basar on the ground that the regular civil court does not have the jurisdiction under the AFR 1945. Thereafter, the landed additional deputy commissioner Basar has disposed of the matter by impugn order dated 11/3/2020, my lord. Now, the finding of the court is this, my lord, at para 12, my lord. Kindly come to para 9. Page 93, my lord. Oh, I'll not waste too much of the time. Neither the deputy commissioner nor subordinate enjoys any power to take dispute of civil nature anymore. Moreover, the Bango level Kaba has not been recognized as a forum for resolving land and river dispute between the parties, and as such, the impugn order of the additional deputy commissioner dated 02/06/2014, referring the complaint of the respondent to Bango level Kaba to decide the land dispute between the parties is without any jurisdictions. Besides, there is also allegation of violation of principle of natural justice as alleged. The additional deputy commissioner has not afforded opportunity of being heard to the petitioner and also to cross-examine the witness. These were the core issues, the core findings. My argument, my youngest argument was accepted by Justice Fukar, my lord. So now kindly come, para 13. In view of above, we find sufficient ground in this civil revision petition, and accordingly the same stands allowed. Now, my lord, here, my lord will kindly recall that decision 26/12/1977, my lord. Judgment has not been interfered with. That is attained finality, my lord. My lord, just recall.
It is still there.
It's still there. So now what had happened, my lord, kindly see.
Because that was never challenged.
Never challenged.
But only thing is that they have filed a separate complaint.
Separate complaint. Yes, correct. So my lord, kindly, para 14 is also important for us, this revision. And in view of the judgment of the division bench of this court in Register General Guwahati High Court versus Union of India and others, and also in view of proviso to subsection 3 of section 15 of the Arunachal Pradesh Civil Code Act 2021, notified on 12/4/2021 in Arunachal Pradesh Gazette, the matter is remanded to the Court of Learned Additional District Judge Basar the parties are directed to appear before the Court of Learned Additional District and Session Judge Basar within a period of 15 days from the date of receipt of certified copy of this judgment and order. On receipt of the order of this court, the Learned Additional District and Session Judge Bashar shall proceed to hear the matter in accordance, my lord will kindly mark, in accordance with law. In accordance with law and make an endeavor to dispose of the same within a period of 3 months from today. Now, my lord is clear that the Bango level Kava order and the impugn order passed by the Additional Deputy Commissioner Basar has been interfered with, was and set aside. And after coming into force of the AP Civil Code 2021, in terms of Section 15, has referred the matter back to the Additional District and Session Judge Basar to proceed with in accordance with the law. Now, my lord has seen in paragraph 12, my lord. Paragraph 12.
Paragraph 12 of this judgment.
This judgment, my lord.
Yes.
So there, my lord will only mark the last 3 lines, my lord.
Yes.
Besides, there is also allegation of violation of natural justice as allegedly the Additional Deputy Commissioner has not afforded opportunity of being heard to the petitioner.
No, that
And-
is there. That is there.
No,
That is there.
that I'm referring, this has a connection with this. This has a connection with this impugn order.
No, that's fine.
So now,
See, I mean, it was a violation there.
Yeah.
Now it has been sent back.
send back,
Now what-
same thing, the same thing has not been followed.
So
The
what is-
direction of this court has not been followed by the Learned Additional District and Session Judge by passing this impugn order, my lord. And here,
If you order is at which place?
this is the basic ground for challenge. My lord will kindly 117. Before that, my lord can also refer to this. My lord will kindly see, my lord will peruse this annexure 12.
Next at 12.
Annexure 12, my lord, page 95 to 1111.
A series.
Yes, this is a series of order which he has passed.
There is a session going.
Yes. This, my lord, I'll not refer to. Only my lord will peruse this, and then my description,
Of orders passed from 95 to page
page 95 to 1111. My lord.
111.
My lord will only refer to my state averment in paragraph 17. That is parent 17 of my RSA, CRP. No? Then, my lord, that is 17, and it is at page number 13 and 14. My lord.
There are 17 and 18.
Para 17, my lord.
Only 17?
It is described in page number 13 and 14.
Correct.
Yes, my lord. That part I want to refer, my lord.
Okay.
Then, my lord, kindly come. Thereafter, then the survey order was passed by himself in 1112 to page 1116, my lord, on 8/6/2023. I'm cutting short, my lord. Just
What is that?
the Additional Deputy Commissioner, the Additional District and Session Judge, he has directed for survey on 26/6/06, yes,
He
5/20,
is directed a survey.
survey of the land. And that-
submit a report.
Then the report was submitted on 8/6/2023, which Lordship will find at page number 112 to 116.
This is the report of the ADC.
No, my lord, that committee, the land department, he ordered the Learned Additional District and Session Judge Basar,
Order the ADC
order the Department of the Land, DLRSO,
to make a survey.
to make a survey, and accordingly, in compliance of that order,
The committee was formed.
committee was formed, and that committee has submitted its report on 8/6/2023, which my lord will find at page 1112 to 116. Now, my lord will kindly come.
What is that? report?
That report, my lord, kindly come. Yes.
Spot verification.
Yes.
No boundary or no. Boundary making. That's a good party. Spot presence of everything. Never present during this. So what we wanted to, what was that you wanted to show me?
No, here I am showing it, my lord, instead of
following the due procedure of trial, the learned additional district and session judge has
Call for a report.
called for the report, which is not permissible.
How-
Because
How it is the council?
he can do it, but at the same time, my lord, without conducting proper trial, my lord, without conducting,
Mr. Tara, like, see, I mean, these are land disputes, correct? And land disputes, without having this revenue or authorities report, survey, do you think the trial can be completed? It becomes very
no,
difficult.
no, I'm not saying. He has done this, within his bound of power, he has done it. The learned additional district and session judge Basar has done it. I'm not quarreling on that. What I'm saying is, my lord, he, on the basis of this map, without following the due process of trial as prescribed by the law, he has just decided 50-50, my lord. So this is
Only on the basis of this inquiry.
inquiry,
Inquiry
map,
report,
my lord.
only on the basis of.
My lord, kindly see that if my lord can afford to come back to page 14 of my civil revision petition.
So your basic,
Now I'm coming to that. I have not yet formulated the
yeah,
question of
but this is one of your grievances, right?
Yes, sir.
One of your grievances is that this only on the basis of this report, a decision has been taken by the additional investigating system.
in
This is
invoking
one of your
invoking, my lord, section 115, inherent power of the CPC, which is not permissibly involved. I have my judgments, I'll place.
yes. Then
Now, my lord, if my lord maybe magnanimous
this please.
to allow me to refer this paragraph 18 and 19 of my
Your
Yes.
petition,
page 14, my lord.
para 18 and 19.
Yes, sir.
Yes.
Let's switch the map. That the petitioner begs to state that as per the directions of learned court below, the report dated 8/6/2023 with map will prepare after the export verification of the disputed land was carried out in presence of both the parties. That's the description which we have read, my lord, from page number 1112 to 116. Now 19. That the petitioner begs to state that the learned in charge additional district and session judge Basar Leparada has passed the interim order dated 9/8/2023 in BSR so and so. Considering the fact that my lord will read along with me, my lord, if it permits, if my lord thinks. Considering the fact that both the parties are by blood relatives and indigenous of Arunachal Pradesh, belongs from Galo community, I am inclined to apply the inherent power of this court in the interest of the justice to both the parties for permanent solution of a case appears on the case record as well as admitted fact as recorded by this court with a direction to make the dispute plot number 3 shown in map to make 50-50 ratio and to demarcate it permanently by installing a permanent pillar to be erected as a boundary which shall be executed by the DC Leparada or SDO at quarter with the help of the LSO, with further condition that the order, that other condition laid down in the first KEVA decision. Well, kindly he has upheld that. First KEVA decision shall stand vacated as he do not have the power, my lord. From where he has got this power? It has attained finality, except for it has not been executed, because that point of time there was no execution court also in Arunachal. He cannot do this. So it stands vacated as it is not executed till.
But this was not challenged also, no?
This was not challenged also.
He himself.
That's why you do not do, you don't have the power.
So he set aside that.
Yes, set aside that.
Shall stand vacated.
Stand vacated. And it is not executed till then. And condition in KEVA decision that Sri Yadav Basar shall not transfer the property to any other person if any shall be vacated. Well, kindly he has overruled, nullified all those, as it is a void conditions. The dispute plot number 4, which is in possession of Sri Yadav Basar, and the undisputed plot number 2 under possession of Sri Jumri Basar shall be continuously in their respective possession forever. it is also directed that Sri Yadav Bazar shall opt the first 50% of the said individual land as he had developed the land first upon the disputed land. Now, my lord, kindly
Why
come.
don't you both go to mediation and settle it?
That is what, my lord, because even they are ignorant, but both of them are fighting in the court.
We tried law. In the Lok Adalats also, we tried. But they were so much adamant. And now they erected the barbed wire around my land. They even not allow me to enter my own
But both of you are brothers.
brothers.
You should settle it. I mean, this court has also said like inherent power has been.
Yes,
applied.
exactly, Your Honor. After that impugn order was challenged by opposite conflicts.
No, therefore, my lord, this since my friend, learned friend has been
No,
conducting trial.
he's trying to make out a case. I mean, he may be having a case. I'm not sure. I mean, this. I think this 151 power has been.
And that is there, Your Lordship, that is there. But what is substantive justice here? That is the point here.
Yes, substantive justice. Then I also wanted to do substantive justice by sending you to mediation and settle it.
Actually, Your Lordship, we have tried a lot before the Lok Adalats also. Only because of their adamance,
Relevancy for what?
they don't ready to give a single portion from the district. That's why this impugn order was challenged before this honorable court.
So now, my lord, the grounds, it is there. Now I have established my two grounds. You cannot exercise inherent power in such kind of cases without conducting proper trial and hearing and opportunity of rebuttal. my lord. Number two,
So basically no trial happened.
no trial happened. my lord. Even, my lord, I cannot call it as a procedural aberration in a lighter vein.
So the land was demarcated only on the basis of that report and applying the inherent power under 151 of the CPC. He has passed an order.
He passed an order without conducting trial. And
He has passed an order and you are aggrieved by that.
I am aggrieved by that.
That is your case.
That is my case. Now, my lord, the question comes, my lord. I formulated, I think that copy is not here, but I'll provide my lord the judgments, my lord. Now, I am on the question of law, I am framing now. Now, the question for determination before my lord is whether a civil judge can use inherent power under section 150.
Have you made it?
My lord, I can provide after some time, my lord.
No, you should give it to me because if you are formulating some question,
Yes,
then it's better I give it to you.
my lord, I'll.
And the first question you are formulating whether he has power.
The first question is whether a civil judge can use inherent power under section 151 of the Code of Civil Procedure to divide disputed land, lease land 50-50 without conducting a proper trial and affording parties the opportunity to present evidence. That the first question is.
Yes, that's the first question.
So kindly provide the CPC to my lord. If you have the
That's 151 is fine.
now, my lord, the answer I'm formulating is
But this is the only question.
yes. So second, now, my lord, see, now these inherent power can be found from section 148 to 153A of the CPC, my lord. These sections outline how the court's inherent power can be exercised in various situations. Here is, my lord, a breakdown of the provision related to the inherent power of the courts. My lord, this section 148 and 149, these sections deals with the granting or extension of time. Section 150 addresses the transfer of business from one court to another.
So the power should be similar. That's what you wanted to establish, right?
Correct.
I mean, the power which has been given, I mean, the examples that has been given, 148, 149.
Correct.
It should be similar.
Similar,
It should not be something very
important, very important.
So the power in the light of these sections, correct?
Correct.
I mean, 148, 149. So like whatever the power is given on the 148, the similar power actually he has to establish on the 149 this thing also, 151 also. That's what we are saying.
Correct, Mr.
Hmm?
So what I mean to say is, Milord, the section 151 CPC, Milord, provides courts with inherent power to make order necessary for the end of justice or to prevent abuse of court process. However, these powers are discretionary and must be exercised sparingly only when no specific provision in the CPC addresses the situation. Here, you have the power for trial. You have not conducted a trial. This honorable court has directed you to conclude the trial within 3 months by following due process of law. Thus, you have violated this.
He is looking at aspect of you, both of you being brothers.
No, well, fine, but I think that the learned additional district and session judge also having that in his heart. Why these two blood
people are
brothers
fighting.
fight? And not to be from my even from my heart and my conscience was initially reluctant to appear in this matter. But then when the client came and the younger accepted the brief, then I cannot say no, my lord. And I'm discharging my professional duty. I don't know what about my learned friend, Mr. Murtaja, that I don't know. But conscientiously, my lord, I was not willing to.
Yeah, I got
appear.
your point, Mr.
So now my lord, see, now judicial.
Now, you judicial presidency.
The official liquidator, my lord,
You have to give me judicial pronouncement.
Yes.
One, one thing is that 151 power.
okay, my lord, that's this particular judgment. My lord will kindly my lord, I am extremely sorry. I'll give the judgment and paragraph, my lord. I think my
No, yeah,
younger,
it's 5 to 7.
yes, the younger who was, my lord, assisting me is not here.
Now, is it 5 to 7 paragraph?
Yes, official liquidator.
5 to 7. Huh?
Yes. No, official liquidator. No, but yes, my lord, official liquidator. And thereafter, I'll rely one more judgment. Para 5.
It talks about additional evidence.
Yes. No, here, my lord, even then that the issue was relating to order 41. Order 41 of the CPC. The
Yeah,
rebate
it
rule,
was
yes.
order 41, rule
Yes.
27.
Now, suppose in a civil court, you are always given an opportunity because here no trial was conducted at all. So therefore, I have some other evidence also.
No, from this case, what do you want to
So-
show?
That first proposition which I want to say is that you have not properly conducted the trial.
No, that-
Thereby, you have denied me to produce my additional evidences to fortify my case. On this proposition, para 5 and 7, my lord, will come. I'll just page 747, my lord, will kindly come.
747.
747, just last, my lord, 1, 2, 3, 4, 5, 6, 7 line. In our view, there was no justification whatsoever for the district court to reject the evidence which the respondent had intended to lead or to disallow the production of documents other than those already produced, and for the reason the High Court rightly ordered that additional evidence be recorded in this case. So that means, my lord, the inference, what I am the principle which I am trying to draw here
It
is,
is very remotely connected, Mr. Tara.
no, but yes, this I'm trying to connect it. Why I'm saying,
Give me something.
no, no,
something
I
more
have,
strong like you,
I have some,
something more strong.
I have some more, Milord. So, Milord, here what I am saying is, had you conducted the proper trial in accordance with the
Then you
law,
have got the opportunity
yes,
to put
I
a
could
giving
not.
evidence.
So this is, so on this principle on, so the hard one, Milord, I have this is, Milord, hey, 2000, can you take up 2008-9 SSC 648, para 56.
2008,
Milord, 2008, 9 SSC
9 SEC,
648,
648,
para 56.
para 56.
Yes, Milord. The Honorable Apex Court emphasized
It
that.
will be a very long judgment though.
Yeah, yes, Milord.
Oh, it is. Yes.
Here, I read this para 56. In the case of Durgesh Sharma versus Jayasri reported in 2008, 9 SSC 648, para 56, the Honorable Apex Court has emphasized that inherent powers under CPC should not be used in violation of specific legal provisions. Para 56. We are unable to agree with the view that in such cases, inherent powers may be exercised under Section 151 of the Code as held by the High Court of Punjab and Haryana in SBF. It is settled law that inherent power may be exercised ex debito justitiae in those cases where there is no express provision in the code. Now, there is an express provision in the CPC how the trial should be conducted. The said power cannot be exercised in contravention or in conflict of or ignoring express and specific provisions of law. Since the law relating to transfer is contained in section 22 to 25 of the code, and they are exhaustive in nature, section 151 has no application. Even that contention, therefore, cannot take the case of the respondent wife further.
Mm-hmm. 46, huh?
Yes, 56, 56.
Yeah, 56.
My lord will indicate that.
Just read it out only.
I read out.
I've heard here. I've heard. I'll keep it.
Now, my lord, I'm relying on one more.
Yes.
1964 SC.
1960.
AIR.
AIR 1964.
For SC 993.
993.
Para 20.
Yes.
In Arjun Singh versus Mohindra Kumar reported in AIR 1964 SC 1993 in Para 20. It was further clarified by the Honorable Apex Court that inherent powers should not conflict with express provision of the CPC. Para 20. On this submission, which we might mention, has been asked for the first time in this court. The first question that arises is whether the court has the inherent jurisdiction which learned counsel contends that it has. For the purpose of the discussion of question and in context of the relevant provisions of the code, it is unnecessary to embark on any detailed or exhaustive examination of the circumstances and situations in which it could be predicted that the court has the inherent jurisdiction which is saved by section 151 of the Civil Procedure Code. It is sufficient if we proceed on the accepted and admitted limitations to the existence of such a jurisdiction. It is common ground that the inherent power of the court cannot override the express provision of the law. In other words, if there are a specific provision of the code dealing with a particular topic and they expressly or by necessary implication exhaust the scope of the powers of the court or the jurisdiction that may be exercised in relation to a matter, the inherent power of the court cannot be invoked in order to cut across the power conferred by the court. The prohibition contained in the code need not be expressed but may be implied or be implicit from the very nature of the provision that it makes for covering the contingencies to which it relates. So therefore, my lord, the learned trial court has exceeded the jurisdiction by exercising power under 151, which he ought not to have done. I will not, even by a stretch of imagination, my lord, I will not question his power to direct for a land survey to submit a report. I will not quarrel on that. But then, however, my lord, the predicament is that the learned trial court, the learned court below,
Rather than conducting a trial, he has given a direction of by himself
Yeah.
only on the basis of the report or whatever.
that's, well, the, even,
This is what you agree with.
yes, my lord,
Had
even-
there been a trial, probably you would have succeeded in the matter. That is
Yes.
your
yes. So, my lord, now this word equity, equity, my lord, will not find in our constitution. But this word equity has come from the Chancery of England. So from there, ultimately, my lord, there is one particular judgment. This is the great contribution by our High Court. So this concept was further developed by our High Court in 1965, my lord, after its establishment. So I forgot that. I have that in my blue book, my lord. So then followed is Supreme Court has accepted the contribution by our High Court.
So what is your point in it?
So now, my lord, why I am referring to is my brother made a small whisper. What is equitable justice? The equitable justice, my lord, it cannot be in negativity, my lord. Even, my lord, while passing this order, my lord, has to balance the conveniences of both the party, my lord. Prima facie case, the three cardinal principles.
You were present when the order was passed?
No, my lord.
You were not there?
No, the client, someone, one of my young advocate for both the parties were represented, my lord. So
That's what I mean. The parties.
yeah, my lord, I'll help my lord. Yes, my lord, K. Bam was there for the petitioner, and Mr. Ansari is my brother Ansari was there. My lord, I'll take a printout of this, my small
Please
note.
give it- I
Yeah.
think you have completed.
Yes, my lord. That therefore,
therefore,
my lord, I am concluding.
Unfortunately, I have understood the matter.
Yes, my lord, I am concluding with this paragraph, my lord. In my conclusive submissions, my lord, a civil judge cannot bypass procedural requirement under the guise of exercising inherent power under section 151 CPC, dividing disputed land without a trial. An opportunity for evidence would violate principle of natural justice and procedural fairness.
You have prepared a written
A
submission.
small note, my lord. I'll give it, my lord. But it was there. Oh, no, this is no. No, this is scope and limitation. No, this all. Yes, my lord. It is here. Luckily. Luckily.
Yeah, it is your written submission. It is your written submission.
Yes, a small portion that I have formulated.
So it will be part of the record. Okay?
Well, fine. So therefore, my lord, even though I have made this submission, my lord, what I am respectfully assisting this court is interfere with this impugn order and remand it back to the additional district and session judge. Let there be a proper trial and hearing. Whoever gets it.
That is your prayer.
That is my prayer. Because Lord, even I don't want even my brother clients also to hurt and my client to hurt. So therefore, my lord,
So you want a fair trial, and like whatever the fair trial court will decide, you are
yes,
happy with that.
within the bound of law, my lord, I am agreeable. But no question of
But not the way,
facts and
not the
nothing.
way it has been done.
The way it has been done. Because once the statute directs you to do a thing in a particular manner, you must do in a particular manner only.
Correct.
Nothing otherwise. Well, that Tata Cellular just.
Yeah, there are a lot of justices. You are Mr.
Murtaza Ansari.
Ansari.
My brother has been coming from Basar, so my lord, I could not say no to him. Because last time there was some difficulty. I was busy with the inaugurational program and all.
Yes, I have.
Yes, well, I have concluded my argument and I will not make any rejoinder also. Whatever.
It's a small issue, and like you have addressed well.
Yes.
So I have also understood. So let me hear him. Yes.
May I, Lordship?
Yes.
Your Lordship, in the year 1977, my father, his grandfather, purchased a plot of land
Together.
together. He singly bought.
You have filed your,
May I?
no, no, who bought?
My father,
And his grandfather.
his grandfather.
Together bought a land.
Yes, Your Honor. Now, Your Honor, may kindly, in my reply, Your Honor, may kindly turn to the page number 89, and it's a 14 of my reply.
Page number
89.
89. Page number 89 is not the whole stuff.
And except for
In your
reply.
reply. Page number 89. Page number 89, there's a map.
Map.
Yes.
This is the plot of land, Your Lordship, which was purchased by my father. This is the whole area.
By your father and his your father and
His grandfather.
his grandfather. Your father and
His
his
same.
grandfather. The same person? Two different persons.
Same person. Harnia person.
So like, yeah, now he is the grandson who is
Yes.
for the court. And like, you are basically his uncle.
Uncle.
Huh?
Uncle.
Yeah.
The fight begins when his father is alive, my brother is alive.
Fight began when your brother was alive.
Alive. And he continues.
He continued the fight.
Yes. So, Your Honor, Lordship, this is the line. And after the demise of my father, this land was divided 50-50, as shown in the map. The bottom portion was cultivated by me, and the portion which was in the top,
Plot A is cultivated by
him. B is cultivated by me.
who has made this?
ADC Basar. This is the first map. Then after, Your Lordship, may kindly turn up page number 92.
92.
92. Page number 9. Another map. While hearing the appeal by the learned additional district judge, this map was directed to be prepared by the land department.
From the report, that report.
Report.
Report also has
Yeah,
this.
already placed.
That already has.
Yes.
Yeah.
In that map, the whole land is described as plot 1, and plot number 2 is cultivated by him, and plot number
No, plot number 1.
1 is plot number 1. Total area is plot number 1.
The smaller one, smaller map.
Total area, total map is plot 1.
That's what, that in your map, the smaller one is the total map.
Yes, Your Honor.
Correct? That is plot 1.
Plot 1.
That smaller version of the map. And the bigger version of the map, there are some distributions.
Yes, distribution.
3 and 4.
Distributions like
4.
plot number 2 is land of Jumli Basa. There is no dispute on this.
Not dispute.
But as far as plot 1, and then, I mean plot
3.
3 and 4.
4.
So 3 and 4, there is a dispute.
Yes, Your Honor.
The
This
dispute
portion
is
were
there.
cultivated by me.
Hmm?
This portion, 3 and 4, is in my position.
In your position, you have been cultivating.
He is disputing. He
One-
won whole land. Your Honor.
The plot
3 and 4.
3 and 4
4.
cultivated by you
Yes,
and in your position.
in my position. And in the impugned judgment,
One second, cultivation and your position. So now, the pencil to the one sharp to that bomb pencils. Let's get some more pencils. Yeah.
and
See, now tell me one thing. The whole plot of land
yes,
was bought by
my father is
my father in this thing.
Yes.
And Jimli Vasar is occupying the portion of the land. This is under his control.
yes, plot number 2.
And what is the area of this?
The total area is 10,877 square meter is,
And how much Jumli Basar is occupying?
Jumli Basar is occupying 10,877. That is plot number 2 in its position.
No, this plot number, yes, plot number 2.
Yes.
And plot number 2 is how much?
10,000,
10,000?
10,877 square meter.
877 square meter.
Yes, sir.
This is Jumli Basar.
Jumli Basar.
And what about you?
Now, Your Honor, as plot number 4 has 2,644.
Plot number 2?
Plot number 4,
Plot number 2 is by Jumli Basar.
Jumli Basar. Now, plot number
Number-
3
3 is by
me.
you. It is how much?
It is 8,385.
Huh.
85
385 square meter.
square meters.
This is your name?
Jumli, Nyado Basar.
Nyado Basar.
Nyado Basar.
And plot number 4
Is also,
owned by you.
yes, you.
How much?
2,644.
644.
44. Yes.
This is Anyado. So now, yes, this I mean, it's almost same, 50-50.
50-50.
Hmm.
Now, Your Honor, Your Lordship, plot number 4. Before the appellate court below, they have no objection regarding the plot number 4. That is 2,644.
Here they don't have any problem.
Any problem?
You occupying this, there is no problem.
No problem.
But 8385,
Yes, they have problem. Plot number 3.
why do you have problem?
Yes, Your Honor. Their problem is illegal. And after hearing both the parties, the learned court below has divided this plot number 3, 50-50.
Plot number 3,
50-50, not whole land. In that case, actually, I am the aggrieved party. With the decision of that learned court below, Your Lordship,
So
actual deprived person is me. Because with that decision, the petitioner in this case has got more than 70% of the total. He already have 10,877, and with this order, which was challenged by the petitioner, he got additional 4,144 square meter. So if we calculate it total, 50-50, then it will be 4,100 approximately. Correct. If we add both the plot, Your Lordship, he will get more than 70%. Rather, I am the deprived person from that income. I have to come before this honorable court to challenge that order.
But he has come, yes.
But he has come. I only stopped because since from 1900 and
No, he got 70%.
70%,
So how much?
still he is not satisfied.
How much he wants?
Total land. No. Natural, where is natural justice? We are brothers. Now he is my cousin.
Yeah, but like now thing is that, see, Mr. Ansari, he's arguing some legal points. Yeah?
Now, Your Honor, I'm coming to that.
I mean, one thing is that, okay, that from the map, I'll have to hearing on this. Yeah, from the map, he's saying that, like, yeah, I can also make out that if 50-50 is done on this,
Only 3, plot number 3.
plot number 3, then
He will get more than 70%.
another 4,000 square meter. will
Another
goes to-
4,000.
goes to him.
Yes,
And he will remain with 2 plus 4,
Four.
around 7,000.
7,000,
7,000, and he will get around 14,000.
14,000. That is more than 70%. Now, the brief fact. In 1977, this plot of land was purchased by my
Is
father.
there any difference in fact? You're disputing his facts?
Yes, on some points.
Like, you tell me, like, what are the,
Yes, in the year 19, 97, as after the demise of my father, they enforces my personal plan. I filed one complaint before the then SDO Basar. Then SDO Basar referred the matter before the village authority. And village authority on 30,
His father was alive at that point of time.
his father, his father was,
His father was there, and I mean, both of yours father died.
yes.
Father was in your favor or what? That
Yes,
the father was in your favor.
yeah, obliged. Yes, exactly. So in the year 1997, after referral by the SDO Basar, the village authority decided the matter on 30/4/1997.
So, like you are saying that, like, though that initial village decision was there in 1979.
1997.
No, the earlier one.
70.
70?
1977.
77.
No, Your Honor, there was no proceeding, no. In the year 1977, plot was purchased. Plot was purchased by my father.
There is nothing on record that there was a cable.
Yes, exactly.
Sorry,
Sale date.
Sale date. It was after filing of the appeal, they produced one sale date. I'm coming to that point also, Your Lordship.
So it was not Keba.
No, Keba.
I said sell.
The purported sale deed was executed in the year.
But there was no Keba order.
No,
It is not Keba. 2017.
But he said something about Keba, one Keba.
No. There is no.
1997. No, thereafter.
Keba was Bango Keba, no, 1997.
Yeah, 1997.
1997.
97, not 77. He confused.
Arey, yaar, how do you dare to say this? This is the date.
So there was no Keba.
1977.
77, there was no Keba.
No, Kevin, 1977, no.
No, Miller.
It's type copy only.
So 1977, Mr. Tara, the land was purchased.
Purchase, exactly.
Correct. And the Keba was not there.
No. I never said about the Kaba. I said was sale date. 1970.
No, you said something about Keba.
No, Kaba is there. 1990.
No, you said about Bango Keba in 1997.
1997. Yes, correct.
And you said that, like, that decision of Keba is still existing. That was not challenged.
Not challenged. That is.
That is not Keba. That was only a how it will be challenged. That was a purchase deed only, if at all.
1977, the purchase took place.
Huh.
Then 1997.
The 1977 purchase. Is there any document?
The document which was relying upon by the opposite party is the sale deed executed in the year 2017 after 30 years. Whether it is possible after actual transaction was happened in the year 1977.
That is, see, I am on the question of law. Disputed question of fact, you can agitate before the trial court. So this is a forum where the question of law only has to be determined, whether the procedural was maintained or not. So therefore, I have fairly said that interfere with this order, let there be a fair trial in terms of the order.
So 1977, there is no Keba. But like there was I have noted it down. You mentioned about this, that Keba decision was not challenged.
1997 Keba decision was not challenged.
1997 Keba is not, it's not like Keba, it's a Bango Keba.
Bango Keba, yes.
There are two Kebas, Your Lordship, in the year 1997.
Ah.
First Keba is the village level Keba. That was held on 30/4/1997.
Maybe that Mr. Tara was mentioning about that.
Yes, exactly.
One village Keba and one Bango Keba.
Bango
right?
Keba, in the same year,
One village Keba and the Bango Keba.
1997.
1997. I'm coming to
And Mr. Tara was saying that village Keba is recognized under frontier rules.
Yes.
just like Bango Keba.
Banga Keba is not.
not.
Yes.
So village level Keba has decided in my favor
In 1997.
1997, the village level.
Because there was some encroachment going on as per your version. Then you have complained before the ADC, ADC or
SDO, SDO.
SDO. The SDO referred the matter to Village Keba. In 1997, Village Keba happened,
Happened.
and Village Keba has decided the matter in favor of you.
Yeah, divided 50,
50-50 they have divided. Village Keba in 1997.
1997. But
Huh.
your lordship, that village level cover was not complied by the other party.
Village Keba decision was not complied.
Not complied.
Not complied by
The petitioner.
petitioner. I am petitioner, and this was actually 50-50 they have decided.
Right, 50,
50-50 they have divided
divided,
the whole plot of land.
all plot.
So it was not abide by them.
Then, that's why I filed one complaint before the same SDO. Then SDO, what he done, he again referred the matter before the Bangol.
All these facts are there in your.
Yes.
It's there. The only has to answer the questions. No, that I have.
Yes, yes. I'm coming
Yes,
to that.
let him be finished with the
Be
facts.
comfortable.
Yes.
Be comfortable.
And
I am your elder.
Yeah.
Proper.
The village level cover was now again placed before the Bangol level cover, which was decided on 15/5/1997. In the same
you have again approached the SDO.
SDO
SDO has referred the matter to village level committee.
committee.
How it has landed up in the Bangor level committee?
Yes, exactly. When he was not complying with that village level cover,
The earlier one.
earlier one, I have supposed to file one execution as a layman. During that period, your lordship, there was no judiciary separate
Execution of what?
execution of 1997 cover.
1997.
Village level.
That Keba order.
Cover order 34
That village Keba order 1997. You have not executed.
not executed.
And execution petitions would have been filed.
No, I simply filed one complaint that he was not complying.
Now, I understood. Now, what is the procedure under frontier rules? That like after Keba decision, you need to
There
file
was no such a confirmed rule about the
then
speaking
then
about
on,
the
on what
execution.
basis you are saying execution has to be filed?
Has to be filed under CPC, your lords, under CPC.
So under CPC, it has to be filed before whom? Before the civil judge.
Civil judge on that time
Civil judge was not there.
not there.
Then it would have gone
Executive
to,
was having the same
it would have
power.
gone to the DC. But
Yes,
that you have not done.
not done.
Okay.
My
Then you have
application,
complained.
yes, I complained
Then again, one Keba was there.
Bango level, not
So why it has gone to Bangor level?
because there was
And what is the difference?
system.
What is the difference between village Keba and Bangor Keba?
Bango level cover as per the
No,
Etena of judgment.
Bango means what?
Bango means higher
Higher than the village level.
village level.
The 4 or 5 villages or what?
4 or 5 villages or for a district or inter village.
So Bangor level committee will be for 4 or 5 villages or in a district one, something like
Yes, yes, higher,
that. Higher up than
higher
than the village level.
village level. Now after
But as per frontier rules,
there is no Bango level,
there is Assam frontier rules, there is no Bangor.
no Bango,
There is no recognition of that.
not
So any order passed by that Keba,
Not-
if you do not comply, then there is no option of yours.
no, sir.
Hmm?
No.
So Bangor Keba decided on what they have decided.
Upheld the decision of the
Village.
village. But in the same Bango level cover, his claim was 3 vigas, 3.2 vigas. And the disputed land in the instant case is more than 1800 square meter,
1800 square meter and
18,000 square meter.
18,000 square meter.
Yes,
Not 18,000 square meter.
Hello, can you give me 1 minute? I'll just come.
Sure.
total land which was bought by my father is
20, around 20,000.
around 20,000.
20,000 square meter.
Yes, sir.
And 10,000 is already
In his
position.
position.
And 10,000 was with you.
Yes,
Then it has become like 2,000 was with you.
yes.
Then 8,000 is disputed.
Dispute.
So how come it has become disputed 18,000?
No, sorry. Apologies.
No, 18,000.
Apologies, Your Lordship.
Oh.
Now,
Disputed land is only for 8,000
8,000.
8,000 square meter.
8,000.
Yeah.
As their claim was changed from time to time.
Hmm.
In the village level Kaba, they claim the whole land, but village level Kaba decided 50-50.
Correct.
Now again, in the same year 1997, in the Bango level Kaba, they claim 3.2 bigas,
3.2 bigha is how much square meter?
4,280 square.
Earlier, village ke baad they demanded the whole land.
Whole land,
Then it was decided 50-50.
50-50.
Now they are claiming the Bango level committee, Bango level authority, they claim
3.2 bigas.
Huh?
3.2 bigas.
3.2 because out of that 50% you are saying.
I got 2 bigas, including the other portion,
You got 2 because
2 bigas. Yes, sir.
and he also got 2 because
1.2 bigas.
he got 1.12 because he got 2
1.2.
because. When it was divided
50-50.
by village
Yes.
village village Keba, then he also got this much 10,000 square meter. He also got 10,000 square meter. Now he again complained. He was trying to encroach.
Yes.
Then you went to the
Yes.
Benga because he was not abiding by the village level committee, village level of the Keba. So then out there, he started claiming another 4,000 square meter from you.
Yes. Out of that 10.
That's what I'm saying.
Yes.
So out of your 10, he is claiming another 4,000.
4,000.
That was the issue before
The
Bango level committee.
Yes.
Now Bango level committee decided what?
Bango level decided 2 bigas out of their claim.
So they claim for 4 weeks. They
three.
claim for 4,000 square meters.
4,000 square.
And Bango level committee has given how much?
Bango level committee has given 2,680 square meter to me. That is 2 bigas.
No, from that
From that 3.2 bigas, that is 4,280 square
from
meter.
which has been claimed by them.
Yes.
They have given you 2 bigas and they have given them 1 point something.
Something.
Some bigas. So it becomes 2,000 some square meters to you.
Yes.
And around 1,800, 900 square meters to him.
Exactly.
Correct?
Exactly.
So that was the decision by the Bango level committee. Now against that, now then what happened?
Then after that, Your Lordship, they kept silence for 1 year.
Silent for 1 year, correct?
Again, in the year 1998, they started encroaching
Okay.
my portion of land.
That is your allegation, okay?
Yes. It is on the record. I filed for the ADC.
No, you have filed this affidavit also,
Okay.
that those pleadings are there. Anyways, that is your allegation. You have, then what happened?
Then I approached before the ADC,
Hmm.
that SDO. Then SDO passed one compliance order of that earlier Kaba, that he has to comply that order. Not exactly execution, impliedly execution, Your Lordship. That order is in the record, placed in the record, and it was not disputed by him also.
Okay, in 1997, Keba, that the what about the order 50-50 was the Bango level Keba was not recognized by SD, correct? He did not recognize that. He recognized only that village level Keba.
Village level.
He said that 50-50 you said. That was the order he has passed. Yes, then
One compliance order was passed by the SDO on my complaint that he was not complying the village level Kaba. After that compliance order, he again remained silent.
okay.
From 1998 till 2014, Your Lordship.
That was SDO's order.
SDO's order.
SDO's order was passed on 1998.
1998.
Which date?
Yes, I'm coming to that.
Okay, 1998 to 2014, he kept silent.
Silent. Yes, Annexure 4, page number 45.
That it will be date
15/6/1990.
15/6/1998.
Compliance order. Annexure 4.
Annexure 4 to your
Yes.
affidavit in
Affidavit in opposition.
Annexure 4.
And it is
he-
admitted fact.
He kept silent for around 16 years, yes.
Yes. Now, after passing of this compliance order,
Hmm.
he remained silent for more than
16 years, yes.
16 years.
Then?
In the year 2014, Your Lordship,
Mhm.
when his father died,
Hmm.
now present petitioner
Hmm.
and his mother again started encroaching the same land.
Jumli is the son.
Jumli is the son. Jumli's father is Nyajum, and I am Nyado. Nyajum and Nyado.
Yeah, you the brothers, yeah, I
Yeah.
understood. Now, your sister-in-law and your nephew came together and again started
Encroaching.
encroaching.
After demise of my brother.
Correct.
Then what happened, Your Lordship? In the year 2014, again they started encroaching the land.
Hmm.
And again I approached before the ADC Basar. And ADC Basar, surprisingly, Your Lordship, referred the matter before the Pango level Kabai, non-recognized forum. And that Pango level Kaba also upheld the decision of that 1997 Kaba, village level.
Original village.
Original village level. Against that Pango level Kaba, they filed one appeal before the, as earlier submitted by CDM,
Mhm.
that they were not satisfied with the decision of that Pango level Kaba 2014. They filed one appeal before the additional district and sessions court Basa
Yes.
under section 46 of
So,
A.
and the additional session just said, no, I don't have jurisdiction, you
Jurisdiction.
go there.
And it was transferred for the ADC,
Because till that time, judiciary was not separate.
not separate.
And civil disputes were
No, judiciary was separated.
separated, but civil disputes were
Yeah,
not
regarding the customary disputed
customary disputes.
dispute.
And
There
land and river,
Yeah.
where has to
There
be
are
decided
two
by-
parallel jurisdictions.
Huh.
So on the want of jurisdiction,
It was
civil
sent
judge,
back, yeah,
district
understood.
judge,
It was sent
but-
back. Then this ADC,
disposed the matter in the year 2020.
Huh.
And again, ADC upheld the village level Kaba of 1997.
the first one.
First one.
Hmm.
And earlier, as I saw the map, Your Lordship, that
That has been retained.
yes, retained.
So that is your case. Then,
Yes.
then,
Then after,
then thereafter, they have gone to the session court.
then after
District and session court.
district and sessions court, district and sessions court transferred the matter before the DC.
Hmm.
DC disposed the matter in the year 2020, upholding the decision of first village level cover
Hmm.
against that judgment and order.
We have gone to this, the district and
come-
session judge.
No, come before this honorable court.
Yes, I'm coming with you.
Before this honorable court, and before this honorable court, after considering the facts, refer back the matter before the district judge, additional district judge, to dispose of the matter as per law.
By Justice Fukon's order.
Yes, exactly.
That has gone there.
Yes,
And the districts and session judge passed that impugn order.
impugn order. it
Impugn
was
order
against-
saying that inherent power of
Yes,
power was exercised and your land was divided 50-50, that to one portion. That whereby you have been actually
yes,
uh,
actually deprived.
you have lost around 2,000
The 4,000
4,000 square meter. And he gained
gain.
2,000 square,
For
4,000 square. That is the thing, right?
And that is
That
the
is the
actual
case.
picture of the
Correct.
case.
Now I got the facts. Now it will be like, what is the legal thing?
Yes,
He has argued that once the matter, whatever was the dispute, whatever is the fact, whatever
No.
is the fact, whatever is the dispute, whatever is the, position of equity, the matter has been sent back to the court.
yes. And court decided.
Court of district and session judge. And district and session judge, we are, without going to a trial, without giving an opportunity of trial to both the parties, he has
Disposed of
exercised
them.
the power of 151, and he has come to a conclusion saying that this much of land is yours, this much of land is yours. So that is his argument. He says that when the matter was sent back to the trial court should not have exercised the inherent jurisdiction, rather than establish the provisional law or procedural law should have been exercised, and on the basis of that, the trial should have been decided. That is his argument.
Yes.
Now, what is your argument?
Yes, sir. While referring the matter, this honorable court clearly quoted that as state of Arunachal Pradesh got his own civil court, that is Arunachal Pradesh Civil Court Act 2021. And under that, under section 15 of that act,
Arunachal Pradesh
Civil Court Act 2021.
Civil Code 2021.
21.
Okay.
Section 15. Section 15.
Section 50 gives what power?
Yes. Run me. The provisions of appeal. The matter arising out of the customary courts. Page number 4. Section 15.
Section
15.
15.
1-5. That's appeal provisions. Appeal provisions. There are sub provisos 1, 2, 3. Then after second last para and now last para, your lordship. Provided further that, may I?
Provided
Further that, from the date of commencement of this act, in case a appeal is preferred against the judgment of customary court in the court of district judge or in the court of additional district judge, as the case may be, the court of district judge or the court of additional district judge may dispose of the same or proceed with the case de novo. There are two options with the district judge. He can dispose of the material available on the record, or he can direct for the de novo trial. There are only two options. And
this is appeal provision.
Appeal provision. And my case is also appeal before the district and sessions court. District and sessions, additional district and sessions court Basar applies the appellate jurisdiction to decide that matter, instant matter.
No, you have not approached, he has approached.
Yes, he has appeal.
Yes, that was his appeal.
His appeal.
That was his appeal.
His appeal.
And under section 15,
15.
when an appeal has been filed, when an appeal is filed, then the appeal from the date of commencement of this act, that is 2021.
21.
In case an appeal is preferred against the judgment of customary court, so he has preferred a appeal against the customary court in civil court of district judge or the court of additional district judge, as the case may be. The court of district judge or the court of additional district judge may dispose of the same or proceed with the case de novo.
De novo. There are two options. Now section 18.
Section 18.
Application of the court, it is CPC. The procedure prescribed in the court shall save in so far as is otherwise provided by this act be procedure followed in all civil courts except in the customary.
151 power is there.
Yes.
He is not disputing that.
Okay, obliged you. Now, Your Honor, my submission will be more clarified from the judgment of Justice Nair.
Justice Nair in which case? Tell me one thing. I mean, de novo.
Yes.
What does de novo means here? In
That
relation,
aspect was,
in relation to this section.
yes.
What
This
do you-
section was
what do you
interpreted.
mean by de novo?
Yes, this section was clarified by the Justice Nair in his decision, which was I just placed before your lordship. In the para 23, it is a CRP 10 of 22. Counsel. Cost. B cost. May I, your lordship?
Para 23.
Para 23. The second proviso to the subsection 3 of section 15 of the Act, said Act of 2021, mandates that from the date of commencement of the Act, in case any appeal is preferred against the judgment of customary court in the court of district judge or in the court of additional district judge, as the case may be, the court of district judge or the court of additional district judge may dispose of the same or proceed with the case de novo. The second proviso to subsection 3 of section 15 of the Act of 2021 mandates the matter in which the appeal from a customary court is to be considered by the court of learned district judge or court of additional district judge, as the case may be. It is open for the court of learned district judge, if satisfied, Your Lordship, if satisfied, to dispose of the appeal basing on the materials available on the record. And in the event there is any doubt with regards to the decision so arrived and for arriving a just and fair decision in the matter, it would be open to the court of the learned district judge to proceed with the case de novo. In other words, to inquire into the issue arising afresh. De novo means arising fresh, but case on hand was proceeded de novo. It was decided on the basis of material what was available before the in the latter, Your Honor.
That is true.
Yes.
That is true. No, what it says.
And now,
No, 1 second. We come to the right, this applicability of CPC, come to this,
yes, sir.
section 18.
18. The procedure
The procedure prescribed in the code shall, save in so far as otherwise provided by this act, be the procedure followed in all civil courts except customary courts. Where is the question of principle coming in?
Yes, Your Honor. But except
Brother, just
It is, CPC is applicable.
applicable
except the
Ex-
rider
Except in
provide,
customary court.
except,
matter arising out.
just brother, yeah, brother, except for the rider provided in section 141 of the CPC, which will not be applicable in the procedure except for the
No, I know that.
that's it. Otherwise, like here, CPC is to follow. Whereas, my lord, I was the man who engineered
No,
this.
this,
act
see, Mr. Ansari, it's not principle. It is CPC has to be followed.
applied in total.
I mean, now you are trying to make out a case. There's only in de novo, only the basis of the material only he can decide the matter.
No, Your Honor. After hearing the parties,
After hearing the parties, on the basis of the material, what material? Only the material before the civil court will be what? Only the material, only the order passed by the Kebang,
and
the village Kebang,
what the evidences enclosed with
recorded in the Kebang.
Kebang.
The Kebang.
and other evidences which was enclosed with his appeal.
On the basis, you are saying that on the basis of that they will go ahead. They will not follow the CPC thing.
The CPC totally not avoided, Your Lordship. CPC will be followed, but not in latter.
It doesn't say about principle. It say about CPC applicable.
Now, On that point, Your Lordship, I have another judgment.
Yeah, you clarify me. I'm.
Yes, after this
see,
judgment,
This, Mr. Nair's judgment, I'm like Nair's judgment with due respect. I mean, see this paragraph. This paragraph on proviso, I'm not very clear. You just make me understand this. See, the one is like, what does it say? The proviso says, provided further that from the date of commencement of this act, in case of an appeal is preferred against judgment of a customary court in civil court or court, as the case may be, that court of district judge or court of appeal may dispose of the matter, dispose of the same, may dispose of the same or proceed with the case de novo. May dispose with the same means what?
in the record available, placed evidences placed on record.
May dispose of the same or proceed the case with a case de novo.
It was clarified. in
See,
the-
like what I understand is two things. Now, because this is an appeal, so this court has the power to hear the matter as an appeal. First thing, as an appeal on the basis of the records which are there, and we can start a new trial also.
Yes,
Separate trial also.
separate trial under Dino. After directing for Dino. In that case also, he only has the power to call the records on, new evidences on, not as a new plain.
No, if de novo, that means de novo. It can.
No, it was clarified in the same judgment,
Which
same judgment. And just I placed before the Lordship, it is land dispute.
see, my understanding of de novo is that whatever has been decided by the village cabal, that is there, but I can start a fresh trial of my own.
Not totally pressed. Your Lordship. Not totally pressed.
Then what is de novo? If you
Now,
check
it-
if it has been clarified here, just show me where.
It was clarified in this judgment.
Okay, give it to me.
Para 23.
Para 23 of
GLT 51, 2023. No. Per May,
page,
Page,
para 23.
para 23. Last page.
Yes.
Another question also arises as to what procedure to be followed in as much as reading of the section 18 of the present act. Regarding section 18, it stipulated that the procedure prescribed in CPC shall save as otherwise provided in the Act 2021 as the procedure followed in all civil court except customary court. And section 52 of the regulation was deleted by section 27 Roman 12 of the Act 2021, taking into consideration that in the customary court, the Code of Civil Procedure 1908 is not procedure to be followed. It is observed that when Your Lordship, when the district judge or additional district judge is exercising appellate jurisdiction against the judgment of a customary court, what the case in hand?
Correct.
The said court of the district judge or additional district judge shall be guided by the spirit of
Series of
CPC.
the civil procedure code. Yes.
This is so because the appeal is a continuation of the
Civil proceedings adjudicated. by the
continuation
civil
of
court.
the civil proceeding executed by the customary court. This court hasn't to add that when the court of district judge or additional district judge exercises the jurisdiction to proceed with the case de novo, the said court shall be bound to follow the procedure mandate in the CPC. bound to follow when de novo is involved. But present case, de novo was not. Now, last part.
No, you are saying that like de novo is clarified, where de novo is clarified.
Yes.
You say.
Yes. Now, next part. In view of the decision rendering herein above, that the impugned order dated so and so is set aside and quashed for the reason assigning herein above, and taking into consideration that the coming into effect of this Act 2021, this court therefore, in exercise of Article 227 of Indian Constitution, transfer the appeal filed by the respondent herein against the petitioner, that is in the matter of so and so, in respect of which the impugned order dated so and so was passed by additional deputy commissioner to the court of District Judge Pasigat for adjudication. The court of additional deputy commissioner Siang so and so shall forthwith transfer the record of the appeal to the court of the District Judge Pasigat, and not less than 15 days from the date of receipt of the copy of this order. The registry is directed
To intimate, what a court.
No, Your Honor. Regarding de novo, there was a clarification, Your Honor.
It's not there.
Yes, I am coming to that.
The de novo means is, de novo means, I mean,
Beginning, Vinod.
a fresh start, a fresh start of the trial.
Yeah, fresh type of trial, but
Fresh start of the trial, and if there is a de novo case, the de novo trial, CPC will be fully applicable.
fully
And
applicable.
in case of that district court is hearing the appeal,
Arising out of the.
hearing the appeal arising of the customary court, then spirit of CPC will be applicable. So what is spirit of the CPC?
Yes, Your Honor. Proceeding.
Oh.
And in the present case, Your Honor, proceeding was followed. In the entire proceeding, before the learned court below, whether they have pressed.
I mean, in this case, that proceeding of village Kepa was called for, no?
Yes.
Nothing was called for. He has done, Milord, page 112 to 160 of my application. Milord will see. From day one, he has not called any records from the village authority. One. Number two, has been passing orders after order, and then had gone for the survey report, and then on the basis of that survey report on. Milord, see, I think both the judgments which my brother has relied has no application in this.
No, only thing is that like, see, if the case record was not called for,
Nothing was called for.
before the district judge, by the district judge, then on what basis he has decided the matter?
No, Your Lordship.
Only on the basis of the appeal petition.
Your,
Whether you have filed any objection?
no,
to
Your that record was already called by the ADC, Your Honor. There is confusion.
that? No.
That confusion was cleared by.
See, ADC, the question of ADC has gone now.
Yes,
See,
Your Honor.
ADC has gone now because against the ADC's order, they have approached the High Court.
Yes.
High Court has sent the matter back to the district court.
Same
So-
appeal.
So same appeal, I understand same appeal. It has been sent back to district court. Now the record of that, the record of that ADC or whatever, all those things are available before district court or not?
Yes.
Along with that village Kepa's record.
Yes, exactly. All the records were remanded back to the district court. It was called by the district court. The
No,
file was with.
See, I mean, two things. He has filed an appeal against the order of the ADC.
ADC.
So against the order of the ADC, I cannot see from that judgment passed by this court sending it back. The judgment of Justice Cooper, that record was called for, and the record has been seen by this court.
That was not.
That was not there.
Not there.
Now, if it is not there, how can you presume that the whole record was before the civil court without calling for the record?
Your Lordship, as the matter was already disposed by the Deputy Commissioner, and that order was only set aside.
Oh.
the appeal was not, that same appeal was referred before the civil court. And while deciding that appeal, DC has called all the records from the village authority. After calling all the records from the village authority, then only he decided. Only the question was that the deputy commissioner has not offered the opportunity to cross-examine the other party. Only on that ground, that order was set aside. And secondly, that appeal was originated from the Bango level Kaba of 2020.
But that was the main ground on the basis of which that has been decided.
As the deputy commissioner has called all the records from the.
Now see, there is one more question here. Now, because it was this customary code of Bango level committee is not recognized under this frontier rules, right? Now, that appeal came from there before the district ADC. So ADC decided the matter. Is ADC decided the matter on the basis of his own materials?
Material.
Correct. Only the appeal has been, because that appeal is, I mean, Bango level is not this thing recognized. So ADC has decided, and after the ADC's decision, that matter has come to the High Court. High Court has sent the matter back to the district court to pass an order after hearing the court, whatever. Now, whether this now the High Court has ruled that Bango level committee is I mean the proceedings before the Bango level committee is void.
Void.
Because they don't have any jurisdiction. Now whether by the district judge can rely on the proceeding which has been which was carried on before a committee which doesn't have the jurisdiction, and on the based on that materials we can decide the matter.
Exactly, your lordship has pointed out the point here, lordship. But while deciding that matter, ADC has called all the matter related to the instant dispute, not only from the 2014.
Is there any order in that regard? Call for records. Where? From where? See, Bango committee. Let us be clarified. Be clear on this. Bango committee was not recognized, so the proceedings before the Bango committee is void.
Void.
Correct. And that is why this matter was sent back. This matter was sent back to district court. Now, district court cannot rely on the materials before that. They can rely on only the materials before the ADC, which ADC has independently called for. Deciding.
Obliged.
Obliged. So, whether those materials were before the ADC or not, this one was before the district judge or not. Because if he hasn't called for those records from the ADC by any order, whether those materials were placed before the ADC or not, that is one question. And secondly, whether he has decided the matter only on the basis of the appeal that was filed from the Bango level.
Yes, exactly, your lordship. But they have filed the appeal against the Bango level. While filing the appeal, that is 138, which was restored by this honorable court. While deciding that, filing the appeal, they have annexed all the documents since from 1997, the first Kaba. And the district DC, deputy commissioner, on the basis of the first Kaba, second Kaba, and that ultimately the third Kaba, decided the matter.
So you want to say that before the district court, all these materials are available.
Available. That's why he also annexed
the basis of those materials, rather than going for a de novo trial.
Yes.
He has decided the matter. But while deciding the matter, rather than taking a look, giving a look into those materials, he has exercised his 151 jurisdiction, called for a record, and decided that.
That is there. That is there. That is there.
So he should have gone on the basis of the materials which are available for him.
Yes.
Rather than doing that, he has gone for, he has called for a report. Exercise decision of 151.
Yes, yes, the records were already called by the DC. And which were, all the records were on the available.
Understood.
Yes,
See, there are two ways he could have proceeded, right?
yes,
One is that a de novo proceeding,
proceeding
and another one that is that on the basis of the materials
available on record.
before him.
Yes.
But while passing the order, let us see the order again. Into order. Page.
In my reply, Your Lordship.
No, impugn order is
In my reply, 47.
no, page.
47.
100. He passed the order on the inherent power, under the inherent power. Not based on the basis of the materials.
Nothing.
It was also recorded on the basis of
118, I'll show one more paragraph. 118. The second paragraph. Under the aforesaid vacancy, both the parties are confused as to who is the appellant in this case. Although the Honorable High Court has directed to appear in this court, but it is difficult to name either of the parties as appellant or respondent, as there is no pending appeal, as the appeals were set aside and quashed by the Honorable. Well, I kindly see there was no application of mine. So I went ahead as a, I don't know. Well, this kindly interfere with, and both of us will agitate before the trial court efforts. At least that much.
how long we fight? How long we fight?
No, Mr. Tara, one thing also there, where I mean, you are becoming, I think from the record, what I have seen, what he has also shown, I don't know if you dispute it, you have become more greedy.
No, not,
You want more and more land. Your father has, your father, your grandfather and his father, your grandfather has decided that he has two sons, take 50-50. Now he is having 50, you are trying to get more from him.
only
Moreover, Your Lord.
maybe plot number 3, Milord.
See, that map is very clear, no, Mr. Tara. See, 10,000 square meter and 10,000 square meter, both were divided, both were given to you. Now you are asking for, you already have 10,000 square meter, and you are asking some portion of land from him also.
No, Milord, that is plot number 1, which is under my occupation, is not at all in dispute.
No, I
The
understand.
dispute,
And
even
what is-
plot number 2 is also not dispute, Milord. Plot number 4 is under his occupation. Rather, he won 50% of plot number 3, which is under my occupation.
No.
Initial agreement was 50-50,
Yes, exactly.
correct? 50-50, it was 10,000 square meter,
Fine.
10,000 square meter.
Milord, I
Moreover,
express,
You have become more greedy, that's true.
no, Milord, on the word greedy, I will express no opinion, nor I make any submission on
This I can see from here. See, now, what I'm saying is that your grandfather, his father, both decided 50-50. Now he has 10,000 square meters. You already have 10,000 square meters. Now you are asking for a little bit more. I mean, see now there, as far as the procedural things are concerned, legal things are concerned, those are different things. But I think if both of you could have settled it.
My lord, who knows if this matter is remanded back in the meantime, there might be a negotiation between them.
There are remote chances, Your Lordship. We tried lot before the Lok Adalat. I personally approached before the other party also to settle the matter.
But that
The main thing is that
I express no opinion on this, whether somebody has tried or not, because I am performing as a duty of the court officer on being power to the power by the
Yeah,
client.
absolutely, absolutely. There is no dispute about it.
I only have to submit on legal
I
points.
have also passed this,
Correct.
use this word in a lighter vein because Mr. Tara is okay. because Mr. Tara is a familiar face.
I am deeply grateful to that.
moreover, Your Lordship,
Only, my lord,
point in this case.
only there is no point because my brother throughout his submission, my lord,
Let us
could
see,
not
like,
answer.
let me examine this.
Yes.
Like I will come to something.
Yes,
Moreover,
my lord will decide by this. Nothing to
Lordship,
argue anything on this.
their point of disputing is that I have no male child. I have only one female child. That's why in the Galo custom, the female child cannot inherit the immovable properties of their parents. That's why if I could have a male child,
This is,
there will be no dispute.
my lord, this is not part of legal pleadings or the
He's
question.
just, he's just trying to make me acquainted with the Gallop.
Not only, my lord, this particular, since I am an origin from this state, I know better than you. Not only in the Galot tribe, across Arunachali
Many-
society, the girl childs are not permitted by
Inherit
convention. By
property.
convention,
Inherit
inherently
It's opposite of this, Khasi Hills.
Khasi Hills, my lord, yes. They're patriarchal,
That's a
we are
written
matriarchal.
argument.
We are patriarchal, then Khasis are matriarchal.
So he has submitted one written argument also.
Let you.
And probably we have given me a short one.
Yes, what?
So that's that. You have a copy with me.
Obliged.
Both of
Fine,
you,
my lord,
both of you exchange and heard Mr. Tara. Mrs. Tara is judging the senior counsel.
Likely, not yet.
Not yet.
It will happen. then.
I'm confused. Mr. Tara and Mr. Ansari, so and so. Hearing concluded. Judgment reserved.
I know.
Much obliged.